2.
Counsel, if you are not arguing the first case, please turn off your camera and your microphone at this point. Thank you. And it looks like everybody has connected to the session, so we will go ahead and get started. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business there, and they will be heard. God save the United States and this honorable court.
Good morning, everyone. Thank you. These seem to be working pretty well. I don't know if the attorneys have participated in one of these Zoom oral arguments, but we've been the members of the court have been pretty pleased with them. We'll still need to take breaks. We'll probably take a break after the third case. Mr. Bachrach, are you ready to proceed?
Thank you, Your Honor. Good morning. May it please the court. Joshua Bachrach, I represent the Appellant Reliance Standard, and I'd like to reserve 3 minutes of time for rebuttal. We're appealing from the district court's decision that Mr. Carlile was eligible for coverage at the time of his claimed disability. That decision is contrary to the language in the policy, as well as decisions from this court. The facts here are largely not in dispute. On March 21, 2016, Mr. Carlile was given his 90-day notice of termination from his employer. He was also told at that time that he did not need to return to work.
Wait a minute, there's some background noise. I don't know where that's coming from. Okay.
I'm sorry, I'm not sure, Your Honor.
Looks like someone sharpening a pencil. Okay, go ahead.
Well, thank you. So Mr. Carlile was told that he did not need to return to work after that. He was also given his remaining salary at the end of March in 2016, but Reliance Standard reached out to the employer and was told that he did return to work, even though he didn't need to, at his convenience. He also attended 2 seminars on behalf of conferences on behalf of his employer. The last one of which was on May 8, 2016. But after that date, there's no evidence that he worked at all. So Mr. Carlile claims that he became disabled on June 9, 2016, which is about a month after he last worked. So
Let me interrupt you for 1 minute. Sure. You say there's no evidence that he worked after May 8th, but you do have the statements from the HR director that told you repeatedly that his last day was in June 7th, I think.
Well, actually, the HR director, Your Honor, said that he worked through the termination period, which ended on June 20th. But we know that's not true because Mr. Carlile himself said that he did not work after June 7th. So that's a problem. We also know that there's no evidence. And I understand Mr. Carlile doesn't punch a clock. He's not he's a salaried employee. But in the Weaver case, which I'll mention at some point, there was actually emails that were provided to show that the person still worked. In this case, there's no emails, there are no letters, no phone records, no nothing. One would think at the very least that Mr. Carlile should have been able to provide to Reliance Standard an explanation of what he did if he was in fact working in June or after May 8th. He could have said, I was working on this project and here's what I was actually doing, and I was talking with this person, because clearly he would have had to communicate with somebody at the policyholder. But none of that evidence exists in this case.
Well, isn't his own testimony evidence where he says I worked in my last day was June 7th, and his employer also says his last day was June 7th? It's
evidence, but it's uncorroborated.
Well,
it's some form of evidence, but it's the weakest form because there's nothing to support it. And again, someone should be able to, and this claim was submitted right away. So it's not like there's a delay and what did I do? I don't remember. There was nothing submitted to show exactly what he was doing. Again, in the Weaver case, there was evidence through emails. There's another case that actually counsel cites to. And in that case, there was evidence that the person closed a deal during the time when the defendant said they weren't working. But here, there's absolutely no evidence at all of any work. But it's not just any work. Again, under this policy, he has to regularly work a minimum of 30 hours per week to maintain eligibility regularly. And there's no evidence that
Mr. Backrack, did the insurance company ask Mr. Carlile what precisely he did after May 8th?
They asked for confirmation that he worked. I don't know that they specifically did to Mr. Carlile, but they sure did to the employer repeatedly when they wrote to the employer and said, we need to know exactly what he was doing, and was told that, well, he didn't punch the clock, so we don't have any information. And
Well,
again,
you didn't ask what he was doing. You asked for his time records, his time cards. And they said he doesn't punch a time clock. He's a salaried employee. And we can, myself and others here, can attest to the fact that his last day of work was June 7th.
well, even if it was June 7th, Your Honor, and I don't think that there is the proof provided, and I think it was requested. There were multiple phone calls and emails with the employer. But even if he came in on June 7th, he has to regularly work a minimum of 30 hours per week. So the question is, when did he last regularly work 30 hours per week? So if he came in on June 7th...
Let me interrupt for one moment, because I'm a little confused about our standard of review with respect to evidence here. This was de novo before the district court, was it not?
Yes, Your Honor.
So isn't it whether the district judge believed the evidence or not? Isn't our standard whether the district court was clearly erroneous?
No, Your Honor.
Pardon?
No, Your Honor. Counsel cited to one case that he said stood for that proposition, but that case, the ERISA claims were actually dismissed at trial. The only thing on appeal that was reviewed were non-ERISA claims. Well, Your Honor, these cases are...
Wait. If it's de novo review before the district court, that means the district court is the fact finder. Isn't that right?
No, Your Honor, it was decided on summary judgment motions. And in the Lasmar case, Your Honor, this court has said that the summary judgment motion is just the vehicle to get the issue to the court. The thing is, Your Honor, Judge Hartz, in a case like this, an ERISA case, you're dealing not with a witness, not with credibility determinations based on what you hear from a witness. You're dealing with a cold record. That's all that you have is a record. And what courts in other jurisdictions have held is in those circumstances that the district court is still not entitled to some sort of deference, because this court, Your Honors, are just as capable of reading that cold record as the district court was. So there is...
Then what do we do with the proposition that there is evidence that he was working in June? And well, you say that's just not enough. So how do we deal with that? If we say we decided on a cold record, if it's cold record, then we have to say there is some evidence that he was working.
Well, Your Honor, you're correct. There is his word that he was working. But how is that different from a disability case where your question is whether he's disabled? And you receive an opinion from a doctor saying he is, and an opinion from a doctor saying he isn't disabled, and the court has to make a determination. So there's evidence on both sides.
But the difference, I distinguish your case on the basis that we don't have any evidence that he was not working.
But Your Honor, it's his burden of proof. It's his burden to prove by credible evidence.
He has come forward with some evidence, both from his employer and from his own mouth.
And I would submit, A, that evidence is insufficient when it's just a conclusion that I was in fact working, and there's no support for it when clearly that could have been provided, and it wasn't. But more importantly, the question is he has to provide proof that he was regularly working 30 hours per week after May 8th and into June 2016.
Regularly working 30 hours a week in terms of whether he was full-time, you're trying to carve it out as to a specific period. I mean, there's no question this man was a full-time employee during his career with the employer. And the issue is whether regularly working 30 hours a week, if I go on vacation, am I no longer a full-time employee because that month I didn't work 30 hours per week? I mean, that doesn't make any sense.
You're right, Judge McHugh, it doesn't. And that's why the word regularly working is in there, so that if Your Honor took a vacation, you wouldn't lose coverage. That is why that precise wording of regularly is in there. So he has to be regularly working, not just, immediately, not the language in this policy.
So he's got to be regularly working up till the claim. Is that the point? So the week of the claim, he has to put in 30 hours.
No, even if it's the week before. So if he is on vacation.
How many weeks before?
Your Honor, on a reasonable basis. It's a reasonable basis. So in this case, when a person...
When we're looking at full-time, definition of full-time under the contract, it's not looking at people that are on vacation or on sick leave. It's looking at trying to distinguish between part-time and full-time employees for the company generally. And generally, the difference is whether you work 30 hours a week or less, right?
I disagree, Your Honor. The term regularly was put in there, and there are numerous cases that we cite to, and even cases that counsel cite to that support our position that say that regularly, when you put that language in there, you look literally at whether that is a regular thing that they are doing. And again,
A regular thing they are doing when? A regular thing this employee was doing up until a point. So that's my question.
Okay, so then you have to include the word active. And active is defined as actually and not contemplative. So and the word full-time is defined as working, not has worked in the past. So he has this continuing obligation to work on a regular basis, at least 30 hours per week for the employer. But what we have here is an employee.
And again, my question is then under your argument, if I'm on vacation and have a heart attack, I'm not covered because I didn't work 30 hours that week.
That's not true, Your Honor. The question is leading up to that, were you regularly working 30 hours per week? And you would have been under that situation.
What about maternity leave?
That's covered.
So during a maternity leave of, let's say, 90 days, so for 3 months, they're not working regularly 30 hours a week, another medical condition, they're in a car accident. No coverage?
No, well, Your Honor, actually, in a situation like that, they would probably be, if they're on leave due to maternity leave, they're collecting disability benefits already from the maternity leave.
Would they be would they be a full-time employee during maternity leave?
Well, they have to be an active full-time employee, and the question is, well, first of all, that's not the situation and not even remotely.
I'm trying to interpret the policy and whether it makes sense. Well, it's part of how we do that.
I understand, Your Honor, but I'm interpreting it as this court has in the past. So I'm looking at prior decisions from this court, including the LC versus Prudential case, which we cite to, which predates ERISA and is based on a common law, but the common law is like the ERISA law. And what that court said, that the person has to be actually working in order to be eligible. And I look at this court's decision in the Bartlett versus Martin Marietta case. And what that court said in that case was, you could have protected yourself in this situation and required a person to be actually working if you said active. And we have the active word here. So what you find are two types of cases. You have those that say you need active, those that say you need regular. And we have both. We have the belt and the suspenders in this case, Your Honor. And I know I'm butting up against the rebuttal time, so I'd like to reserve the remainder of time.
Just a minute.
Yes, Your Honor.
On the question of remand, why doesn't the case that the district court relied on, Spradley versus Owens, Illinois, hourly, why doesn't that just decide that you lose on that issue if there's a question on that?
Well, because under Ray versus Unum, this court held that when there has not been sufficient fact finding, case has to be remanded. And we cite to a case from the Seventh Circuit that says you don't have to hedge your bet in court reversing the basis for your decision and decide issues that aren't present at that time. So the issue,
but the decision in Spratling says if you're going to raise issues as to the denial of the claim, as distinguished from the calculation of the amount of the claim, you better do it all at once. And that's the way I read Spratling. And so doesn't that mean if you lose on the liability issue, is it the only question is how much do you owe?
no, Your Honor, I read it differently. I read that case as saying that you have to put all the bases. So if we denied the disability, saying that you weren't disabled under the facts, but later say, oh, you know what, there's a pre-existing condition exclusion, and we now rely on that. We couldn't do that, but that's not what happened here. This was, you're not covered under this plan, and therefore we didn't have an opportunity to investigate all of that. And I point out, Your Honor, there are facts that show, A, he returned to work early in the next year. And the district court itself said, I did not decide that issue of whether he remained disabled throughout the 90-day elimination period.
It's because you didn't raise it.
No, that's not what the district court said. In fact, and I know I'm over, Your Honor. I'd like to save time for rebuttal.
Answer the question. We'll see about rebuttal.
Well, I appreciate that, Your Honor. So the district court said, we said it should be remanded, but what the district court said was, I never said that the only issue I decided was the one of eligibility under the plan. I didn't decide that he was disabled. So since the court didn't decide that issue, somebody has to, and it has to be Reliance, because there is no decision on that.
The district court said that an issue isn't before me. It says that's not what you raised before me, right? I mean, I guess you can go down and you could file another claim or another case, but the district court said that issue's not before me, and besides that, you conceded that he was eligible, that he's 100% disabled.
That's a false statement, Your Honor. That counsel.
Well, this is a quote. Only let me quote what you said. We are not disputing the fact that as of June 9th, 2016, Carlile would have been deemed totally disabled under the policy. I mean, that's right. A direct quote.
It is, but they are saying that as of June 9th, but he had to remain disabled for 90 consecutive days to be eligible for benefits. And there was no determination that that was made. And again,
totally disabled is capitalized, and it's a defined term in the policy, which includes the 90-day period.
Understood, Your Honor. But again, there was no need for Reliance to determine that. There's no discussion of the medical evidence. So that was a statement that maybe the person who wrote the letter stated more than they should have, but that wasn't the intent. I can tell you that, Your Honor.
Wait, I'm looking at the court's order after you moved for reconsideration. It says, the court's order and judgment reflects only the relief requested in Carlile's motion for summary judgment, which was to conclude Carlile was an active full-time employee and thus eligible for benefits. The court made no determination regarding what defendants owe under the terms of the policy. Any challenge to the court's order and judgment on that basis are misplaced. To the extent defendants are challenging Carlile's continuing disability, that is not an issue for remand, but would involve new proceedings. I gather from that the court is saying you're not foreclosed from having a dispute with Mr. Carlile regarding how much you owe him, but the court has not decided that. Am I reading that correctly?
You are, Your Honor. The reason that we still included that as an issue was the court in first order refused a remand. So the case is sort of, the claim's in limbo. It's not at the court anymore, but the court said, I'm not remanding it back to you for any further investigation. So we just needed some clarification on that issue.
Okay. Thank you. Mr. Dushku?
Yes, Alexander Dushku for the plaintiff, David Carlile, and may it please the court. Good morning, your honors. I think the colloquy has ventilated many of the issues, many of the weaknesses of Reliance's position. Let me point out just a few things regarding evidence that he was at work. There is plenty of evidence that he was at work, including in June. Their own letter of June 12, 2017, where they deny Mr. Carlile's administrative appeal, repeatedly on at least 6 occasions acknowledges that you ceased work due to symptoms of an eventual diagnosis of prostate cancer as of June 9th. And repeatedly they go through and admit, the date bounces around between June 7th, 8th, and 9th, but repeatedly they admit that he was at work during June.
So let me ask you this. If he was at work for a half hour in June, and that's all, is that enough for him to be an active full-time employee under the policy?
Yes.
And how do you come to that conclusion?
Yeah. First of all, taking the latter of those two terms, full-time employee, as the briefing has refined this down, even Reliance admits that what's going on there is that you have to, in the course of your regular, what your regular schedule is, what you were doing regularly, are you still kind of in the realm of what that is? And so it doesn't require that you work every single week. The cases, the Bartlett case, for example, involves someone who had not gone back to work for a couple of months and was still considered a regular full-time employee.
But in that case, the court, we said, look, if you wanted to limit your coverage, you could have added active to the requirement. We basically said, hey, insurance companies, this is how you do it.
Yeah, what you said was if the defendant wanted to limit benefits to regular full-time employees who were actively working, it could have done so. So that language, actively at work or active work, it actually appears in this policy as a defined term, but it doesn't. But the word active is not so defined. And in the Tester case, which this court endorsed in its Weber decision, the court dealt with that very same issue and found that the term active in connection with full-time employee, that the word active was ambiguous. And then in that case, they went on to demonstrate, to hold that an employee whose last day of work was in January 8th, and who died in February was still an active full-time employee at the time of her death. And here's what the court said in Tester: an employee would reasonably expect that his coverage continues while he regularly works for the company, even if he is home with the flu or injured in a car accident. And that gets back to Judge McHugh, your colloquy that you had in that regard. The term active really means, are you doing anything to advance the interests of the
Let me ask you, you have to be, you need to be full-time, is that correct?
Yes, within the meaning of
right.
policy, yes.
And the first month that you're not full-time is the last month of coverage. If you're not working full-time in February, you're still covered in February, you're just not covered in March if you're not full-time then. Is that correct?
Yes.
Okay.
That's how I understand it.
Now, when he was told, you don't have to come in for your last 90 days, at that time, if that was all we knew, are you saying he would be a full-time employee because of what he had done before he was told you don't have to come in anymore?
What I would say is that he remained a full-time employee because he was not terminated. he was still working.
Okay, so even if he put in no work his last 90 days, you would say there's coverage because he was still a full-time employee.
Yeah, I'm not prepared to die on the hill over that proposition because he did come in repeatedly through his.
Well, let's assume that he's not. I'm trying to figure this out. So let's say he's no longer a full-time employee once he's told you don't have to come in at all. But he can still satisfy it if his regular work week is 30 hours or more because he actually comes in, as Reliance has admitted. There were some weeks, even in May, when they assume he must have worked 30 hours because he was at a conference. And it's hard to be at a conference without participating for 30 hours. But that ended by mid-May, as I recall, was the conference. So there's no evidence he worked anymore in May, after the middle of May. Then it seems to me, we'll answer this, I shouldn't say it seems to me, explain to me why he still has a regular work week of 30 hours or more if he's told you don't have to come in, and in fact he didn't come in for the last 2 weeks of May. Why did that coverage not end at the end of May as a result?
Your Honor, he did come in. The evidence indicates he did come in during his notice period. So he was a full-time.
I'm talking about, yeah, I know during the notice period, and we're okay with the first half of May when he attended a conference, put in at least 1 30-hour week. But either you'd have to rely on the fact that he was working full-time just because he hadn't been fired, regardless of whether he showed up, or you'd have to, and if you're not relying on that, then you have to show that he did have a regular work week of 30 hours or more during that 90-day period, but the last evidence of his working a 30-hour week is for a week in the first half of May. So why was he, under what theory did he still have a regular work week of 30 hours or more the last couple months of May? What's your theory there?
Yeah, the cases treat the notion of a regular work week as being what it was that employee has done, especially historically. It doesn't have to be every single week, certainly not while the person is ill.
Right.
And what we have in the evidence, I want to push back just a little bit. Ms. Miller says, quote, "I, along with other employees, can confirm that he had worked in the office throughout his notice period." So that was from the time he was given notice all the way until June 7th, through June 7th. And that was the repeated response of the employer in response to Reliance's questions.
And you think that's enough, regardless of whether he worked a 30-hour week? He actually worked a 30-hour week.
Yes, it is enough. The evidence is that he was doing what he had always done. He was a vice president of marketing. He was in charge of drumming up business. He was never a time puncher. He was working. He's a highly salaried employee, and he was working to drum up business as he had before. His hope was that he could do what he did in 2014, where there was a downturn, and that is drum up business and get things going. And so he was working. He was working in May. That's where he did go to conferences, and he continued to work. That's what the evidence shows from Ms. Miller. He continued to work until his final day, which was June 7th. And I think that is and that is sufficient when they're talking about when they're talking about a regular.
What I have a problem with is that there's one really distinctive feature in this case that I don't think was in any of the cases cited, and that was he was specifically told you don't have to work your last 90 days. So given that, I would think there has to be evidence that regardless of what he was doing before that 90 days, that he was regularly expected to or regularly doing a 30-hour week.
Your Honor, he was not terminated. He was still a full-time employee during his notice period. That was by his employment contract. So they had to give him notice. He was a full-time employee all the way until June 20th of 2016. And he continued to work until June 7th when his disability rendered him unable to do so. And I've not seen anything in the cases that suggests that he didn't have to come in, means that he wasn't still a full-time employee. He was coming in. Ms. Miller of the HR department there indicated that, quote, he has been eligible since his date of hire with no gaps in coverage. And that's volume 2, A582. And so he continued to work. He was still a full-time employee. He continued to do what it was that he had done before. And by the way, this is an important point. Reliance admits that he was covered as of the end of May. So they're actually not pushing the point that you're pushing, Judge Hartz. They admit that he was covered as an active full-time employee through May. Well,
did I say anything to that suggests otherwise? I was saying it would, if he didn't work the 30-hour week in the last part of May, that wouldn't prevent his coverage in May. It would prevent his coverage in June. It's the last month. If you no longer have coverage once you go a month, if during 1 month you are not a full-time employee, your coverage ends at the end of that month.
Yeah. If you cease to be an active full-time employee during a particular month, your coverage ends at the end of that month. Now they admit that he was.
They're arguing his coverage ended in June, right? That because he made his claim in June and Reliance rejected it. Am I right on that?
I understand Reliance to be making the argument that his coverage ended in May.
Right, okay, he was not covered in June.
And my point here, Judge Hartz, is that he continued to do in June for the first 7 days the same things, same types of things that he was doing in May.
How do we know that? I mean, you've got a question for his time records, and then you've got a response that there are no time records, and you've got I think Ms. Miller indicating that he was working throughout the notice period, but there's no, that I've found, information about what he was doing during that period, nor do I see anything contrary to opposing counsel's argument that indicates that the insurance company asked for it, but I don't see anything that says, other than the conferences, which we have evidence of, I don't see anything that says what he was doing.
We have a question from Reliance, and this is volume 2, A582. These are emails. Quote, please confirm last full-time active day worked for Mr. Carlile. And again, essentially quoting the language from their own policy. And the response is, and there are a couple other questions asked, he chose to come into the office at his convenience during the months leading up to his termination date. His last day worked was June 7th. So her response to the question, please confirm last full-time active day worked for Mr. Carlile was June 7th.
But that's not responsive to what we were talking about, which is what specifically did he do during the first week of June? I think that's what Judge Hartz was saying.
Yes. I see that I'm about to run out of time. May I respond?
Go ahead. Yes, please.
Question? Yeah. He was doing the same thing he had always been doing.
Where's the evidence? Point me to the record.
Well, we don't have any specific, I don't have a specific site for you other than that he came into the office and worked throughout his notice period. That is what Ms. Miller said. Now, they never asked him. They never picked up the phone and called. They have a fiduciary duty. Never picked up the phone and said, hey, what have you been doing? They didn't do that. They asked for specific hours. They didn't ask for whether he worked over 30 hours. And so he was, our understanding is he was drumming up business for the company and was hoping to be able to revive and help the company to move forward. So.
Anybody on the panel have any further questions?
No.
Mr. Backrack, I'm going to give you 30 seconds, but you're going to stop at 30 seconds sharp.
Thank you, Your Honor. Just quickly, counsel said that the employer said that he worked throughout the notice period, but the employer said at his convenience. At his convenience does not equate to regularly working 30 hours a week. That's the key question here, as Your Honor has stated. And also, I think it's important to note, as Your Honor, Judge Hart said, that there is no evidence, and Judge McHugh, there is no evidence of exactly what he did. He could have provided that evidence. Thank you, Your Honors.
Thank you. Thank you, counsel. Interesting case. Case is submitted and counsel are excused.
Thank you, Your Honors.
Oh, want me to call the case then? Okay. We'll do 20-3005, Page versus Commandant. Mr. Meyer.
Yes, good morning, Your Honor. I'm sorry.
Did I pronounce your name correctly, Meyer or Mayer?
It's Meyer, Your Honor.
Yeah, okay. You may proceed.
Thank you, Your Honor. Good morning. May it please the court, John Meyer on behalf of the appellant, Jeffrey Page. Good morning to counsel for the United States. And I'd like to make 3 points during this morning's presentation in the context by first setting the factual background that this is a tragic case where 2 young American soldiers were deployed to Jordan, and without getting into too much factual detail, one soldier, the appellant, shot his buddy and killed him. The issue at trial solely was the mindset at the time the fatal round went off. And I'd like to begin with the first point being the lower court failed to apply this court's holdings in Monk and Dotson, which state that when there are substantial questions of constitutional law that are largely free from factual issues, it is appropriate for an Article III jurist, an Article I district judge sitting in the 10th Circuit, to reach the merits of that constitutional claim and adjudicate it. The lower court's decision...
Wait. I don't know of anyone who has a steeper hill to climb to get relief than someone representing a person convicted through a court-martial who's appealed through the military justice system.
Well, we're working on that hill, Your Honor.
All we have to look at is whether the issue is considered. And it sure looks like it was considered.
I respectfully disagree, Your Honor. And here's why. The lower court, the district judge sitting in Kansas, he refused, even though briefed, to consider this court's holdings in Monk and Dotson.
You're saying the district court?
Yes, Judge.
Yeah, well, we don't really care. This is de novo.
Right. Yes, Your Honor.
What had to be considered, where it had to be considered was in the military justice system.
Right. So if we return to the...
And how was it not considered in the military justice system?
The standard to be applied for the Article I tribunal was whether or not prevailing Supreme Court standards were applied and whether or not those considerations raised on direct appeal in the Article I system were fully and fairly adjudicated. And our position based on the record is counsel had 12 witnesses available to him on the single issue of whether or not Specialist Page intended to kill his buddy rather than whether or not this was a mindset of culpable negligence. And defense counsel under Strickland v. Washington never called any of them, to include 2 police officers and 2 police reports, which were exonerating in terms of actual guilt, because Page pled guilty to manslaughter. He knew it was a terrible mistake and he regrets it to this day. But at the same time, the government went forward and tried to prove up murder and premeditated murder and did. But the challenge, though, was the testimony of those 12 troopers who were on the ground for 5 months with Page never made it to the inside of the courtroom, Judge. So on a direct appeal, Page raised that very constitutional issue to say reasonable counsel would have called those witnesses, especially when counsel was at the pretrial hearing and heard the verbatim transcript where they said, in the 5 months in the Jordanian desert, we saw nothing to indicate that Page wanted to kill anybody. As a matter of fact, we think it was a terrible accident. But
Let me interrupt. You seem to be proceeding on the assumption that prong 4 of Dodson, whether
Yes,
fully and fairly considered, means that we review it for whether it was decided correctly. And I see these as 2 different issues. One is, did the military tribunal fully and fairly consider the issue? Not when it decided it, did it make a wrong decision?
Well, yes, Your Honor, I agree with that assessment. There are 2 different questions to be answered there. But one of the main points that I'd like to share with the court, as we make, I hope, clear in our papers, is the Article 1 Tribunal on Appeal ignored an entire body of manslaughter case law. And to ignore prevailing precedents on point cannot constitute full or fair consideration.
How do you know it ignored it? How do you know it ignored it? Were these cases that were submitted to the tribunal?
Yes, Your Honor. They were written, they were cited, they were applied.
Yeah.
And they're mentioned nowhere in the opinion.
Well, I can tell you, just because we don't cite something in an opinion doesn't mean we didn't read it and consider it. There's no requirement that an Article 1 tribunal list every case it considered in reaching its opinion. Is there? Can you point us to something that says?
No, Your Honor, and that's not the position that we're presenting. Instead, if we take a step back, we have 12 witnesses, 2 police officers, 2 police reports, and an entire body of law that was ignored, all sitting in front of us, wrapped in a transparent bag. And the Article 3 courts of the United States are reluctant to touch it because they think that the Military 1 Tribunal had the expertise to get that right.
Well, let's
look
at the merits a little bit. One of your arguments has to do with that they didn't look at the contents of Mr. Page's computer. And the court said, the fact that he doesn't have anything on his computer saying, I want to kill another person, doesn't in any way advance the ball. It's irrelevant because it doesn't tell us what was in his head. You might wisely not put it on your computer. I mean, that's a rational decision, isn't it?
It is, but it's only half of the decision because the prosecution...
Let's keep going. Your police, the officers, the investigatory officers, made a very preliminary assessment that through further investigation, a different conclusion was reached to charge him with a higher crime. The court said they didn't really have much to offer because they were very early and they hadn't done much. Again, that's rational.
Your Honor, that's with regard to the Air Force Office of Special Investigation report, but the Army CID agents, 2 of whom fully investigated the cases, did a forensic analysis, interviewed canvas blanket interviews of the entire number of personnel who were there that day, testified under oath that in their experience, they saw nothing in Page's mindset that he wanted AP, the victim in this case, terribly, to be killed, to be murdered, that it was a tragic accident. So to take a step back here, how can we as Article 3 American jurists, when we look at 12 witnesses, 2 reports, counsel's fully unaware of them, our client is sitting on trial for life and admits that it was a tragic accident, and you don't even try to put these people on. And then the post hoc justification on appeal is, I didn't think any of that evidence was admissible. And that's a misapplication of the rules of law. So all of these things come together to say, how can this trial in Article 1 appeal be fully or fairly considered? And I'd like to refer the court to Burns, the plurality decision in 1953, which states the plurality agreed that if the process is inadequate to resolve the substantial constitutional claims, the Article 3 courts, as the ultimate arbiters of what the law and the Constitution is, should evaluate the merits and make the decision. The deference to the military courts is not appropriate. And here's another example. Your Honor, if one of your clerks, for example, this morning didn't come to work and didn't come to work for a second day, Her Honor, you may counsel that person or you may fire that person. But, in the Army or in the Marine Corps or the Navy or what have you, if they don't show up, that's an offense. That's the offense where deference by Article 3 jurists to Article 1 military justice officials should come into play and still survives. But when you have the Sixth Amendment and Strickland v. Washington, plus the ignoring of an entire swath of case law, all of that coming together presents the fact that this young man did not get a fair trial. And by virtue of that, that's why we appealed. So yes, admittedly, the scope of review is very narrow, but we believe that looking through Burns, Monk, and Dodson, the question before the court is substantial, largely free of any factual issue, and one entirely appropriate for the district judge to have adjudicated. And there was no reason to pass it along. Even though the court wrote, there are those circumstances which this circuit, and in this circuit it's still good law, where even though the court has written, the court's going to say, you know what? A defective in jury instruction goes to the cornerstone of due process. We're going to write on it. You know what? Another defective in jury instruction, even in tumor.
Let me get back to these specifics here.
Yes, Your Honor.
Essentially, you're saying that the military tribunal did not properly review a claim of ineffective assistance of counsel. Am I correct?
That is a piece of it. Yes, Your Honor.
And the ineffectiveness that we're talking about is the failure to call 12 witnesses who would say the defendant never expressed any desire to kill the victim.
In the 5 months, I'm sorry, Judge.
Anything more than that?
Yes, in the 5 months with which I had served with him in the desert for 12-hour shifts, I saw no animosity. I saw nothing between the two of them that would ever give me reason to believe. I knew both of them. And in the time that we served together in that, we call it dog years when we're overseas, I saw nothing that we didn't conclude. And as prudent defense counsel was at the pretrial hearing and heard this verbatim testimony, the transcript of which is before the court right now. And you can read the testimony. We don't know how reasonable counsel under prong 1 of Strickland v. Washington can say, I'm not even going to try to put that on. It's a difference between life and 10 years. It's a difference between premeditated murder and manslaughter.
You said that's one part of it. What's the other part of it?
In terms of, the other part of it, Your Honor, is the court was briefed. The Article 1 military tribunal was briefed on a body of case law where manslaughter, where soldiers were pointing rifles at each other, pointing pistols at each other, throwing a hand grenade into a shower tent, all of which constituted culpable negligence, not specific intent to murder. And the lower court and the military tribunal completely did not consider any of it. And that's problematic because Burns counsels that if the process is legally inadequate, one of which being defining legally inadequate as failing to apply prevailing standards. That's where this case is very problematic. And admittedly, the standard of review is narrow, but this is the kind of case where the Article 3 jurists, the district court has the authority, if not, I dare say, with respect, the obligation or duty to say, you know what, the Constitution wasn't observed here. And a young American soldier who was on the National Honor Society, who was 22 years old, who had never fired his rifle before, who was looking through a broken optic, who was monotonous in the desert, and as soon as he fired his rifle, ran out to help his buddy, said, "Oh my God, I admitted it," tried to plead guilty 3 times to manslaughter. The prosecution would have none of it. But then when he did, he finally pled guilty to manslaughter the 4th time naked. In other words, without the benefit of a deal. Then the prosecution went forward with 11 witnesses, not one of whom can provide any evidence of intent to kill. At the same time, defense counsel had before him a very robust case, and those of us who have been prosecutors and or defense counsel, you would have to call those witnesses and develop them. And so under Strickland, ordinarily, we would provide tactical deference, right? But the post-trial affidavit defense counsel submitted was all inadmissible. I would have drawn objections. And that's why we spent some time in our papers before the court saying Rule 601, 602, 701, 702 says that laypersons can describe what they saw, providing the trier of fact with inferential information to say, you know what? Even though that round went off, there was no direct evidence of specific intent to kill, especially when the Article 1 tribunal and the Article 3 court below ignored the definition of the statute. The very statute itself before the court gives an example of what manslaughter is, and that's when 2 soldiers point their pistols at one another, believing them to be safe in the unready to fire position, but they're ready to fire, and 1 soldier is killed. That's what the example is in the manual for court-martial. That standard too was not applied. So you put all of this together and you say, how many standards have to go unapplied before an Article 3 jurist, the expertise of a jurist, in other words, and not to besmirch my brothers and sisters on active duty, I'm a lieutenant colonel myself in the reserve, having prosecuted and defended, that they're military officers first, managing careers. They're not dedicated jurists. So the idea being, you can't ignore all of those witnesses who would have come in. And if I were on trial, my God, I would be so saddened that I'm doing 26 years in the penitentiary when the case law says I should be doing 2 to 3.
Thank you. I think we understand your argument.
Yes, Your Honor. Much obliged, Your Honor. Thank you.
Mr. Mag.
Good morning, Your Honors, and may it please the court, Jared Mag, on behalf of the respondent, the Commandant of the United States Disciplinary Barracks. Your Honors, I think this court can appreciate that these types of cases are very fact-dependent, and that Mr. Marr's plea for this court to accept the idea that a body of case law exists that supports his position somewhat misses the point. Certainly there are cases throughout the military appellate system which demonstrates that certain events and certain acts on behalf of soldiers supports the idea that manslaughter is the more appropriate charge, but those are very, very fact dependent. Each case is really burdened with its own problems and its own facts. There's not one uniform set of facts that applies in a manslaughter situation. And
I should interrupt for a minute. I kept thinking someone might tell me what evidence came in as to the motive and intent here, and I really didn't see anything.
So, Judge McHugh, the evidence that the Army presented during the court-martial proceedings involved the rebutting or dismantling petitioner's argument that he had chambered around the day before and had mistakenly assumed that he had cleared his weapon. Through that, they were able to rebut petitioner's arguments that he had in fact chambered around during an event which is described as the sand truck event, where he had gone along with 2 other service members to approach a sand truck that was approaching the entry control point and that he had chambered around. The government had put on evidence to rebut that, showing that that sand truck incident did not happen the day before. In fact, an event that other soldiers were aware of, which was a significant event involving the Jordanian forces and the American forces, were occurring the day before, and that no trucks had come to the entry control point because of that event involving the Jordanian military force and the Americans. And so for all intents and purposes, they had demonstrated that the base was somewhat shut down. So the petitioner's argument that he had in fact chambered around during that event was in fact disproven by the facts that that sand truck incident didn't occur. Secondly, they relied heavily on the fact that the petitioner would have had to have, on 4 separate occasions, decided to forego his training and not clear his weapon. And they described all 4 instances where he would have had to have, as the process is when an infantryman clears their weapon, there were 4 points in time where he would have had to have actively decided not to follow his training and therefore decide to simply hand his weapon in, not clear the weapon via protocols, and allow that round to continue to be chambered in his weapon. Third, they were able to put on what the military qualified as an expert, someone who would have to demonstrate that the shot taken by petitioner was a very thought out, deliberate act on his part because of the distance, and had to go through the process of chambering the round, thinking through the process, narrowing the focus of the shot, and actually hitting the victim, in this case in the head, from several meters away. And at the end of the day, that evidence was presented. Now, here's what's important, I think, to circle back to what Judge Hartz had said, is that while the Army Court of Criminal Appeals did not look or did not give a written opinion on this, which they're not required to do, and this court has well-established precedent which says that this court does not take into account the fact that they did not take into consideration or did not write an opinion about this issue. I think that cuts against petitioner's argument, because if you look at footnote 3 of the opinion from the Army Court of Criminal Appeals, it's important to note they granted appellant's motion to attach their verbatim transcript of the Article 32 hearing, which means they looked at and considered exactly what he wanted to be placed in, because the Article 32 court heard the evidence of the service members who Mr. Mayer talks about testifying to the lack of any motive on the part or any animosity on the part of Specialist Page and the victim. Now, at the same time, this court has to appreciate Article 66 of the Uniform Code of Military Justice, and that is important here because it obligates the Army Court of Criminal Appeals to review the record in full, in a de novo, if not a hyper de novo review of the record, to determine and satisfy for itself that the defendant was in fact guilty beyond a reasonable doubt of the crime for which he was ultimately convicted. At the same time, I think it's important to remember that his case was tried to the court. It was not tried to a panel. And the judge that was taking into consideration this evidence when looking at the record did an extraordinary job of identifying the rulings at which he was deciding as to whether or not to admit certain evidence. He was giving basis for those rulings and establishing a significant record. And at the end of the day, this court has made it very, very clear in a number of opinions that it does not sit to reassess the facts of a case that were fully and fairly considered.
Did the military tribunals consider and comment on the position of defense counsel that he didn't think this other evidence was admissible?
So, yes.
Determine on whether that was effective representation or not.
If the court reads, if in the Army Court of Criminal Appeals opinion, they cite to the Strickland standard and reference the fact that that evidence would not have been admissible as opinion evidence about what other members thought or what they saw because it was opinion testimony. The court was clear that in its opinion that the case revolved around the moment in time when Specialist Page decided to pull the trigger in this case.
So the military tribunal ruled that, in fact, this testimony of non-hostility that would have been provided by 12 people in the unit would not have been admissible. They said that?
It stated, it is, and I'm reading from the opinion, Judge Hart says, it is impermissible for a lay witness to testify as to their personal opinion as to whether appellant possessed a specific motive or intent to kill. And they ultimately made that determination that that would have been inadmissible. Now,
well, but that's not, I mean, yeah, they can't get on there and say, I opine he didn't have the motive to kill. But what they can relate properly is that I spent, 72 straight hours with him and I saw him interact with the victim, and never did I observe any animosity or aggression. Right?
I think that's a fair
two
statement.
Different issues, right?
That's a fair statement, Judge McHugh, but at the same time, I think the court has to appreciate where the defendant's counsel or where petitioner's counsel were at the time. And two issues that they really were, I think, referenced was the idea that if they put those individuals on the stand, it opened up the idea that there was quite a bit of animosity toward this victim. And for Mr. Mayor and I have great respect for Mr. Mayor, so don't take this in the wrong way. These were not buddies.
Okay, well, in the material, the record, there is a suggestion that presenting these witnesses would have backfired, but because there was some negative evidence that it would have opened up. But sure isn't much to tell us what we're talking about. It's all sort of vague and obscure of what it is. So it is hard to assess.
Again, Judge, I think this is what highlights the point. It may be obscure for you. It was not for the Army Court of Criminal Appeals. They had the record from the Article 32 hearing before it. And that is critical for this court's analysis to determine whether or not there was full and fair consideration. Because at the end of the day,
that transcript of the record is important for our analysis, is what you're saying?
It was important for the Army Court of Criminal Appeals. It's important for your ultimate analysis, Judge Hart, as to whether or not full and fair consideration was given by the Army Court of Criminal Appeals.
Is that part of our record on appeal?
I do not believe that I believe that it is. Mr. Marr did put the Article 32 transcript. I believe that's the largest part of the appendix in this case.
Now, there was hostility apparently after the victim was promoted. Do we know how long before the shooting that promotion was?
I don't have any evidence at hand to know that he was promoted, how far in advance he was promoted. We simply know that there was a bit of animosity based upon some of the statements or some of the things that the victim was saying to other service members that were crude or otherwise inappropriate, as well as his advancement, which appeared, or it would seem that his advancement was not well received by other members in the unit. And then that is coupled with the statement that petitioner makes after the shooting, when it is presented that he laughed and said that the other members of the unit would find it funny that he killed the victim because everyone hated him so much. And that statement was, of course, placed in front of the court at the time as well, which further established some sense that maybe there was a motive in this case. And the government highlighted that statement that Specialist Page had made just shortly after the shooting, and to indicate that statement led at least toward the idea that there was something more that was going on here.
Does the Article 32 transcript include anything about the concept of dry firing being authorized and encouraged?
I don't know, Judge Murphy, I don't know that there's a dispute that they encouraged service members to engage in dry firing at inanimate objects. That was a common training, but certainly they trained against at every turn to ever dry fire at another service member. It was trained to shoot or trained to aim at inanimate objects only. But
is that in the Article 32 transcript?
I believe that there is some discussion. Well, I suspect that you'll find there's quite a bit of discussion about what is called glassing or dry firing. But glassing, of course, is aiming at another service member to try to, when they dry fire, instead of pointing at an inanimate object, they would in fact point their weapons at other service members. The extent of that, I think, was certainly it could have been in dispute at the time as to whether or not that was going on a regular basis. But at the end of the day, the Army Court of Criminal Appeals appreciated the fact that it came down to the point in time as to whether or not the petitioner had the intent to shoot, and stacked against the evidence which rejected and refuted at length his argument that he had chambered around. The court ultimately concluded that the trial judge was correct in convicting him of the more serious charge. But in the very short time that I have left, I cannot understate that this court's standard of review is so incredibly restrictive in this sense. And it is important to remember that, again, that this court really does not sit to reassess facts that were fully and fairly considered. And these facts were briefed at length by both parties. And I think you can see that from the Army Court of Criminal Appeals opinion when they realized the narrow set of circumstances that they had to look at to determine or satisfy for itself as to whether or not the petitioner was actually culpable of that offense. And that standard should apply under these circumstances. And unless the court has questions.
Your time has expired. Any questions from members of the panel? Thank you, gentlemen. Case is submitted and counsel are excused. Now call our next case, 20-3056. Reorganized FLI versus Williams Companies. Ms. Coy, you're first. You're smiling because I was told how to pronounce your name, which is totally misspelled.
Very impressive, Your Honor. Thank you.
Go ahead.
May it please the court, Jennifer Coy on behalf of Appellants Dynegy and Williams. I'd like to reserve 3 minutes for rebuttal, please.
Okay, you know how that works. You've already seen that, right?
Yes, Your Honor.
Good luck.
Thank you. This appeal arises out of Kansas antitrust litigation, and it presents a single question of law for this court. Does the Kansas legislature's 2013 repeal of one of 2 remedies that were available for Kansas restraint of trade violation apply retroactively when the change left intact both the substantive cause of action and a treble damages remedy for one who both proved liability and sought that remedy? The answer is yes, the change applies retroactively for 3 reasons. First, under black letter Kansas law, changes to the remedies available to enforce a right apply retroactively by default under the core principle that a plaintiff who has not proven liability has no vested right in any particular remedy over another remedy. Second, The Kansas legislature could have exempted this change from its default retroactive status, but the legislature did not do so here. It instead codified the default rule. And third, a change may not be applied retroactively to abolish a vested right. But this case presents no such problem. Again, a plaintiff who has not proven liability has no vested right to a particular remedy. And the change here left both the substantive antitrust cause of action and a treble damages remedy for one who sought it, like farmland's class counterparts represented by the same counsel. Kansas law is clear that this...
Well, I'm going to interrupt you. I think it's clear as mud. What do we do with the Kansas Supreme Court statement that Section 5115 creates not only a new procedure for relief, but also new substantive rights?
Your Honor, when the O'Brien court made that statement, it was citing several provisions of the KRTA. It cited 102, which is a substantive provision, along with citing the remedial provisions, including 115 at issue here. So a statement that the KRTA, including its substantive provisions and its remedial provisions, creates substantive and rights and remedies, doesn't change the equation here at all. The Kansas Supreme Court did not say that Section 115's particular remedy was some sort of substantive right. And the question at issue in this Kansas principle of statutory interpretation is, did the change affect a remedy or mode of procedure, or did it instead affect the underlying rights and wrongs? And looking at what the courts have said, it's clear here that what the change affected is the remedy or mode of procedure. So take Brennan, for instance, Your Honor. That's a 2011 canonical Kansas Supreme Court case. And it addressed a situation in which the change lowered the amount of damages a plaintiff could recover because it allowed the defendant to offset the plaintiff's insurance proceeds. And the court squarely said that change is remedial because it doesn't go to the underlying rights or wrongs. It affects the remedies and procedure at stake.
But what about Klebrink? However you pronounce it. Seems to me they reached the opposite conclusion there.
Absolutely, Your Honor. They don't reach the opposite conclusion there for two core reasons. First, as Owen Lumber in 2003 and Brennan in 2011 made clear, the earlier Kansas decisions used to intertwine the analysis of remedial and substantive with vested rights and due process. So what you have underlying those cases is a court looking at the vested rights concerns and intertwining that into whether the change is substantive or not. That case concerned core vested rights concerns that are just not at issue here. First, that case...
the cases you keep ignoring are the two Court of Appeals decisions from Kansas. And under Stickley, when we are doing an Erie guess, we have to give those some weight. And you essentially tell us to ignore them. And I can't ignore them. So help me out.
Absolutely, Your Honor. Our position is not at all that you should ignore those cases. It's that those cases do not address this question. O'Brien 2 specifically explained that it was addressing the law as it stood prior to 2013. It acknowledged the fact that there had been changes. It acknowledged that the legislature said that the rule of reason, one of the substantive changes that happened, would apply retroactively, but not to pending causes of action. And then it moved on to its analysis. It did
Wait. O'Brien too said that the amendments did not apply to a case like this one that was pending before April 18th, 2013. And that's a quote. I just quoted you from O'Brien 2.
Absolutely, Your Honor. The O'Brien 2 court did not address the precise question of whether remedial changes. It did not look at the Kansas retroactivity law. It didn't look at this question. Just was not before.
It said globally, generally, that the amendments did not apply to a case that was already pending. And Smith specifically said 50-115 does not apply retroactively to a case that was already pending. Right?
Your Honor, you're right that both of those courts of appeals opinions made broad statements, but neither court, in neither instance, was this question raised. Neither court took any analysis of the Kansas retroactivity principles. Neither court held that these changes didn't apply retroactively because the change does not fall under the Kansas default rule, or because there is a vested right at stake, or for any reason. The court made big picture pronouncements that, in accordance with the ordinary rule for substantive changes, that changes do not apply retroactively, and nobody in those cases raised the question of whether changes to remedies applied retroactively. What you have here, though, Your Honor, is the only cases that address the precise question at issue here squarely thought this was a straightforward application of Kansas law, saying that that changes to remedies apply retroactively by default because the plaintiff has no vested right in any particular remedy. Your Honor had asked about Clybrink, and I want to turn back to that for a moment because that addressed a situation in which the liability, the consequence to a defendant was increased for past conduct, and that squarely implicates a defendant's due process rights to not have new consequences imposed and have his property taken based on past conduct when he had no due process notice, no fair notice of the consequences of his action. That is an entirely different question than here, where it's under the canonical principle of Kansas law that a plaintiff who has not proven liability has no vested right to any particular remedy. Brennan conclusively addresses an issue like in Clybrink, where a change lowers the amount of damages a plaintiff can recover, and this court squarely says that change is remedial. And I want to talk for a moment about the Knoll and Nash opinions.
Just a minute before you go on. What if there was a case where the Kansas law only provided for treble damages, and the Kansas legislature amended that and added full consideration damages, and your client changed that? Wouldn't your client be saying Clybrink applies?
Your Honor, we would not be saying Clybrink applies, but we would have an argument, yes, under the modern doctrine, which separates the remedial substantive discussion from the due process discussion. I would have no dispute that the change was remedial. It doesn't go to the underlying rights or wrongs. I would have an argument that I have a vested rights due process problem there, and that's because the property interest at stake for the defendant at issue in that type of instance is different under Kansas law. Kansas law determines the property rights at stake, and Kansas is telling you that a plaintiff who has not proven liability has no vested right to any particular remedy over any other remedy because there are all these contingencies still outstanding before recovery. So you can interchange a remedy. A defendant has a different due process interest in not taking his property, his money, and making you take money not out of the public coffer, but out of that defendant's pocket and pay the plaintiff based on past conduct with no notice of the additional consequences. So absolutely.
Let me ask this then. If the Kansas legislature in this case had eliminated both full consideration damages and treble damages, you would still say that applies retroactively, even though their only remedy now is injunctive relief?
No, Your Honor. If it had taken rid of, if the change had gotten rid of all of the remedies available, that's exactly the Brennan case. Brennan looked at a change that lowered the amount of damages a plaintiff could recover. This is the canonical 2011 opinion. And it said the change is remedial, but it found a due process violation and did not apply the change retroactively because the change eliminated the only remedy at stake. Here, if all the money damages available are completely taken away, then they'd have a strong argument that Brennan is on all fours. And even though the change is remedial, the default rule doesn't apply because it abolishes their vested rights. But the key point here is Kansas's vested rights determination turns on whether the law itself abolishes the vested rights, the change, not on a party's failure to act on an opportunity the law provides. And your honors, the Knoll and Nash decisions tell you that conclusively. In both cases, there is a change in the law that puts in a new deadline. In both cases, the new deadline doesn't go to the underlying rights or wrongs, so it's remedial or procedural. In both cases, the change ultimately bars the remedy altogether. The plaintiff has no damages at all when he otherwise could have recovered. And what the Kansas court said is the plaintiff had an opportunity to comply with this new rule. He just didn't do so. And the timing in Nash is 2019 is particularly instructive because it is the exact same year and a half at issue here. Nash, the change took effect on July 1, 2015. On January 7, 2017, the Nash court said that the plaintiff's action is barred. He loses his remedy because he didn't comply with the new rule and had a year and a half to do so. Here, the change happened in April of 2013. In October of 2013, the plaintiffs were told by a state district court in Kansas, this change applies retroactively. In February of 2014, the plaintiffs were told by a federal court in Ohio, this change applies retroactively. On the exact same day at issue in Nash, July 1, 2015, this case came back from remand from the U.S. Supreme Court, and it remained pending in the district court that entire year and a half that Nash said was more than enough time to comply. And not once in that time period did farmland seek to amend, like its class counterparts had done, to protect its interests. Under clear Kansas law, the plaintiff cannot create his own due process rights. Your honors, if I may, I'd like to reserve my time.
Ms. Goy, let me ask you this. If you lose and this is deemed to be not retroactive, are you ready to go to trial?
No, Your Honor. The fact discovery closed, but expert discovery is still ongoing.
Then let me ask you this. What if we agree with you, but decide that in fairness that farmers ought to be able to have a treble damage remedy? Since you have more things to do, more discovery, what prejudice is there at all to your client for allowing them to have treble damages?
First, we would be strongly prejudiced in they haven't put on any fact or expert evidence that is conclusive as to.
But you're in the middle of discovery. You said you're not ready to go to trial. You're doing discovery. Well, just put that in the discovery. Get your experts and focus additionally on damages.
Yes, Your Honor, we are prejudiced. We would be prejudiced in having to defend against a claim that they took strategic positions over time using the fact that they only sought the other remedy. They took positions that mattered in this litigation.
You're absolutely right. They did take those positions. What I'm asking, what is the prejudice to you?
The prejudice to us is that we have to litigate against a claim that they should not be allowed to bring. And Rule 15 looks
but that's not what. How are you prejudiced in defending against a claim of treble damages? That's the question I want answered.
We would have to go take expert discovery on treble damages, which is different than on full consideration. We would have to go. There might be facts that come into play that would have to reopen fact discovery.
Right, but you're in the midst of discovery right now.
Fact discovery is closed, Your Honor. Just expert discovery is still ongoing, although the case is stayed below. But Your Honor, Rule 15 says undue delay and dilatory motive is enough reason. May I finish my answer, Your Honor?
Yes.
Is enough reason to deny leave to amend. It's reviewed under an abuse of discretion standard, the leave to amend. Rule 16, which applies here because the scheduling order deadline has already passed, says good cause. And in this court's Husky Ventures case from 2018, the court said a delay of just a few months, less than 6 months, was sufficient to say that the district court did not abuse its discretion in not allowing an amendment because there was no good cause for that delay. We have no dispute that had they sought to amend immediately upon remand from the Supreme Court or anytime soon thereafter, this would be a completely different question. And I can't imagine why a court would not have granted leave under that circumstance. But the fact is they had an entire year and a half while the case was pending before the trial court then. And then they even had time after it came back. It was only up on appeal again.
We understand your argument on that.
Thank you, Your Honor. And if I may, please have a little bit of time.
Judge Hartz, can I just ask
Yes,
one?
please, yes.
Ms. Coy, why shouldn't we certify this question to Kansas and let them tell us?
Your Honor, you shouldn't certify this question for a few reasons. This case has been pending for 15 years. Nobody's requested certification, and this just does not present one of the exceptional circumstances in which Kansas law does not provide a clear and defined path for you to follow. Kansas law tells you that a change in remedy.
Okay, you don't need to go through all your arguments again.
Okay, thank you, Your Honor. Based on the Curiae case and the Alexander case from 2018.
Thank you.
Yes, thank you.
Thank
Okay. Ms. Pope?
May it please the court, Leslie Pope on behalf of Plaintiff Appellee Farmland. Farmland filed this lawsuit 15 years ago under Section 115 of Kansas's antitrust law. Section 115, which is reproduced at page 17 of defendant's brief, gave any person injured or damaged by a price-fixing conspiracy the right to sue for and recover the full consideration or sum paid for the goods affected. The Kansas Supreme Court has described Section 115 in O'Brien 1 as creating substantive rights in the form of a private right of action for a specific type of damages. Despite this, defendants argue that Section 115 was merely a remedial provision, and thus its repeal is retroactive, effectively stripping Farmland of a claim it filed 15 years ago. Defendant's argument is wrong for 3 reasons. First, stripping Farmland of its claim would be contrary to the intent of the Kansas legislature and the savings clause it included in the 2013 amendments. Second, because Section 115 was a substantive law and its repeal was a substantive change in Kansas law, it must be applied prospectively. Third, even if Section 115 could be construed as a merely procedural or remedial provision, the repeal of Section 115 could not be applied retroactively here because doing so would have the practical effect of stripping Farmland of its claim and violate due process.
Let me focus on the third issue. It wouldn't strip you of your claim if you had pursued treble damages. Is that correct?
No, Your Honor. Section 115 creates a private right of action. As Judge McHugh referenced in O'Brien 1, the Kansas Supreme Court explained that Section 115 in itself creates a private right of action. And this is clear from the text of the statute, which is available at page 17 of defendant's brief. The statute says that any person injured or damaged by a price-fixing conspiracy in Kansas may sue for and recover the full amount paid for the goods affected. That may sue for and recover creates a private right of action. It also creates liability against a defendant. Those are 2 factors that the Kansas Supreme Court has looked to in defining what is a substantive law that creates a substantive right. So it creates its own cause of action. There's a separate cause of action in Section 161.
Okay, are you ready to answer now? Why did you not also pursue a claim for treble damages?
In our complaint, we cited both Section 161, which creates the right for treble damages, and Section 115. But as we were entitled to do, we focused on the full consideration remedy that was available in Section 115.
You affirmatively said you weren't seeking the treble damage remedy, isn't that correct?
Prior to 2013, we did repeatedly make the choice to focus on the full consideration remedy, which was available to us.
Why was that advantageous to you to not bring the treble damage remedy? What possible reason would you have for not pursuing an available remedy? You can usually seek 2 remedies. There's nothing wrong with that. What was the advantage to you or your client in not seeking treble damages?
There are multiple advantages to focusing on this Section 115 private right of action. As explained in O'Brien 2, there's a different standard of proof under 115 and under 161. So to recover full consideration damages under 115, one needs to show that one was injured or damaged and then the amount you paid, as opposed to if having to show the amount of the overcharge in order to establish.
Please, I don't think you're responding to my question. It's fine to focus on one, but what was the advantage of abandoning treble damages? Did it affect any discovery, any procedural advantage? Was there any reason why you would affirmatively abandon that?
Yes, there was additional discovery that would have been taken had we focused also on the treble damages remedy.
And you didn't want to engage in that discovery. So you said, we're not going to seek treble damages, so that discovery is irrelevant. Is that right? We made
clear that we were focused on the full consideration remedy.
We were focused. No, there's a difference between being focused on one of two remedies and abandoning a remedy. So you abandoned treble damages to avoid discovery. And that was back before 2013. Is that correct?
We focused on the section 115 for full consideration damages because those were the damages we were seeking.
Yes,
not because.
But the reason, why abandon it? You affirmatively abandoned it because you didn't want to submit to discovery. Am I wrong about that? Are you able to answer that question? I'm not talking about why you preferred remedy A to remedy B. I'm asking why you affirmatively said we're not seeking remedy B. And as I understand it, it was because you didn't want to be subjected to discovery, factual discovery. Yes. Is that correct?
Yes, and the benefits of section 115 and the fact that it has a different evidentiary standard.
But also it's a lot more money, right? I mean, full consideration is every dime you paid as opposed to just the difference between what it should have been charged and what was charged, plus you get to treble it. So there's a huge difference in the amount of damages.
Yeah, but that's not my point. The point, you can pursue that, but you abandon one alternative so that you wouldn't be subjected to discovery. And if you pursued that claim now, you would be saying, yes, you can conduct this discovery even though it's been 8 years. I don't know how hard it is to get the evidence now, but you didn't want to submit to discovery. Were there any other reasons why it was advantageous to you to abandon the treble damages remedy?
No, there were no advantages to the abandonment. There were benefits to section 115 full consideration damages.
And that, yes, and that makes perfect sense for you to prefer that remedy. But you didn't want to submit to discovery that would be relevant only to treble damages. So you said, we're not pursuing that claim. Is that a fair characterization of what happened?
Yes, it is fair to say that there were categories of discovery we said were irrelevant because they didn't bear on full consideration damages, which is what we were seeking.
Now, ordinarily, that would be a waiver because you affirmatively decide to do something to get an advantage. I'm curious whether the waiver analysis would be a matter of federal law or state law. Do you have any position on that?
No, Your Honor.
But it was a knowing and intelligent abandonment of a claim, was it not? You wanted it because it advantaged you. Am I correct about that?
No, I don't think it's correct to say that we abandoned our claim under 161. As I mentioned, 161 and 115 are separate causes of action. And 161 also...
Weren't they allowed to take discovery with respect
to... 161 isn't just limited to triple damages. It also provides attorney's fees and injunctive relief and other forms of relief that we continued to pursue and were never disclaimed.
But you specifically abandoned the claim of treble damages, and you did that knowingly and intelligently, knowing what you're doing, because it prevented discovery that you did not want to be subjected to. Is that fair?
It is fair to say that, yes, there were categories of discovery we took the position were irrelevant because they didn't bear on the full consideration remedy that we were seeking.
Ms. Pope, these times that you made the affirmative decision to run away from treble damages, all that occurred before 2013 when the Kansas legislature acted, correct?
That's correct. And it's also worth underscoring that
at that time, the knowing part of this was that you knew that you had a full consideration remedy, correct?
That's absolutely right. And for
it's only after 2013 that you knew that if it was retroactive, you would lose that.
After 2013, we continued to have every reason to believe that we would be able to continue to pursue the Section 115 remedy. It's worth underscoring that defendants themselves didn't raise this issue for an additional 4 years in any case, and didn't raise it as to farmland until 2018. If they really believed that our only cause of action had been extinguished immediately by the 2013 amendments, one would have expected them to raise that immediately and not continue to litigate the case for an additional 5 years. But yes, the case was effectively on appeal from 2011 until 2018. And for that reason, there was very little time in the district court when this issue would have come up.
Now, as I understand it, the other Kansas plaintiffs, the class, they were, during most of the time, represented by the same lawyers as farmers, correct?
That's correct. And defendants do point out that...
Let me ask you this. I don't know if it's in the record. Is it in the record, the applicable complaint, original complaint, and any amendments to the Kansas class action case? Are those in the record?
I believe that they are included in the appendix, yes, Your Honor.
Now, as I understand it, sometime before 2013, that Kansas class sought to amend their applicable complaint to add treble damages, and that was denied, correct?
Your Honor, I'm afraid I don't know that I thought that it was granted, and it was before the 2009 deadline for amending the pleadings, but I confess that I do not know the answer to that question. But one of the things that shows that defendant's argument that we should have simply amended at the same time as the class is spurious is that the deadline for amending the pleadings was in 2009, 4 years before these amendments even came into place.
And the MDL court denied the opportunity to amend for that very reason, correct?
Denied farmland the opportunity to amend subsequent to the deadline, yes.
Denied the class the opportunity to amend because the time had expired.
I'm sorry, Your Honor. I was not an attorney that represented the class, and I do not know the answer to that question.
Sorry.
I'd like to address one point that was made about the increase versus decrease of damages. Defendants have taken the position that even if it is the case that a change in the law that generally increases damages is a substantive change in the law, a change that generally decreases damages would not be. That's contrary to the great weight of authority outside of Kansas, as defendants in fact acknowledge this themselves, because in footnote 13, in footnote 27 on page 13 of their brief, they cite two cases that they claim are consistent with Kansas law, in which there was a diminution in the relief available to a plaintiff. And both were categorized as substantive changes in the law that could not be applied retroactively, which goes to show that the change, whether it's an increase or decrease in the amount of damages, is substantive in Kansas, outside of Kansas, all across the country. And that's consistent with what the Kansas Supreme Court told us in Killebrink, that the great weight of authority holds that an increase, decrease, or repeal of a damages provision is a substantive change in the law that is not applied retroactively.
Well, if it were procedural, one of the things that has bothered me is when we're sitting in diversity under Erie, you'd have a different measure of damages in a federal court than in state court, right? If it's not substantive. Wouldn't that be true? I guess that's really a question for Ms. Coy, but it seems that it complicates the Erie analysis quite substantially if we start treating it as a procedural rule.
Your Honor, I think it's clear that this is not a procedural rule. It's not a remedial rule for all the reasons we addressed in our, I see my time is up. May I address the question?
Briefly.
It's neither procedural nor remedial. The Kansas Supreme Court cases tell us that a remedial or procedural change is one in the means or methods by which the substantive right is enforced. And this statute, section 115, clearly falls on the other side. It is a substantive change in the law because it's a substantive change in the amount of damages. It's a law that gave and defined a right. It's also a law that created liability against a defendant.
Thank you. Ms. Coy, I'll give you a minute.
Thank you, Your Honor. Very quickly, may it please the court. Counsel for Farmland said that this case was on appeal from 2011 to 2018. This case was not on appeal for the precise July 1, 2015 through January 2017 time period that the Kansas courts have told you was more than enough time to comply with a new rule. So I just wanted to quickly clear that up. Second, Judge Murphy was asking about the amendment sought after 2013. No party sought an amendment after 2013 on any basis saying we have good cause because of this change in law. And if they had, that would be a different story. But the only issue in an amendment after 2013 was to add a federal claim, which was denied as long after, there was nothing new that changed in the law that would implicate it. They also say this created a private right of action. Your Honor, the identical right of action to vindicate the 112 cause of action exists in 161, it existed before, continues to exist today. The Kansas courts have never held that a change to money damages is a substantive change. Brennan tells you precisely the opposite, Your Honor. Thank you.
Thank you. Thank you, counsel. Case is submitted. Counsel are excused, and we'll take a 10-minute break. Thank you.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you. We're ready to proceed with our next case. 20-3082, Animal Legal Defense Fund versus Kelly. Mr. Lau, do I have that? Am I pronouncing your name correctly? Both of you have your mics off, and I see Judge Murphy's mic is off also.
That is correct, Your Honor. My name is Brant Lau.
You may proceed.
Thank you. Good morning to the court and counsel, and may it please the court. My name is Brant Lau. I'm the Solicitor General of Kansas, arguing today on behalf of the state of Kansas defendants, appellants, who are the governor and the attorney general. In 1990, the Kansas legislature passed the Kansas Farm Animal Facilities Protection Act, prohibiting unauthorized entry to animal facilities by those who intended harm. Nearly 3 decades later, the appellees here challenged the act as an unconstitutional violation of their free speech rights under the First Amendment to the United States Constitution. The district court agreed, but was wrong for 3 essential reasons. First, the act does not regulate protected speech because entering private property is not speech. Second, the act does not regulate protected speech because false speech intended to inflict damage is also not protected. And third, the act is not improperly content or viewpoint based. As to the first reason, the Kansas statutory protections do not regulate speech because they concern non-speech conduct. The provisions are all premised on and prescribe entering an animal facility. Entering private property, even when access is premised on a lie, is not speech, and regulating that entry is effectively a form of trespass. The United States Supreme Court has recognized that the First Amendment does not create a right to trespass. This traditional First Amendment principle was not changed by United States against Alvarez, which was relied on by the district court.
Well, it's not a question of whether the First Amendment protects you from a trespass action. The issue is where you're not barring all trespass, but you're only prohibiting trespass that's based on certain intended speech, if you can do that under the First Amendment. So it's a question of whether not whether you can use the First Amendment as a shield here to protect you from trespass, but rather where you limit the scope of the trespass action based on the speech that is intended or the speech that is made to get the job, that is different.
Well, we would contend, to use your analogy, that this is an attempt to use the First Amendment as a sword to gain access to private property that is traditionally protected by trespass. And that's the first element of speech, the lie that is told to obtain access, a lie that was specifically referred to by Justice Kennedy in the plurality opinion in Alvarez. And then the second element of alleged speech is after the lie has been used to commit the trespass is used as leverage for the additional speech about what is going on in the facility trespassed upon. So there are 2 layers of alleged speech arguments. We believe they're both wrong. They essentially revolve around the illegal trespass and are certainly within the legislature's discretion to regulate, the legislature having regulated trespass for since statehood, frankly, in Kansas.
That's what I was going to ask you. Go ahead. I can.
No, you go, please.
Okay. When you say traditionally has prohibited trespass, is there anything prohibited by this statute that is not prohibited by the general criminal trespass statute in Kansas? Is this just is the whole purpose to increase penalties, in other words?
The penalties are different, and that would be the primary focus. Certainly, common law trespass on the civil side and criminal trespass on the criminal side both pre-existed this statute. And we believe that criminal trespass could have included the use of falsehoods to obtain access to the property. But the Kansas legislature chose to make a policy decision to enshrine that into this statute and to provide for, at least in a couple of circumstances, different and more severe criminal trespass penalties.
Well, there's a Kansas Court of Appeals case that says that consent to enter property is invalid if it's through deceit. Is that not part of the criminal trespass law in Kansas also?
Certainly, and I assume the case you're referring to is the KA, the television station case from 1979, and there the court found that there was a jury question about whether consent was given. So yes, that pre-existed.
So my question was: is there anything prohibited by this statute that was not already prohibited by Kansas's criminal trespass statute?
I think that offenders could have been charged under the existing statute before this statute existed. You're right, that there is an overlap. But of course, that's not unusual in the law. Any criminal indictment.
I'm asking, I'm not saying it was bad or good. I'm just trying to get it straight, what the law was. You say there was an overlap. Is there something prohibited in this statute that is not prohibited by the criminal trespass statute?
No, we don't believe so.
Okay, that's all I wanted to know. Thank you. Go ahead, please.
So what is the purpose of this statute then?
Well, the purpose is, first of all, the different punishments. This trespass statute contains several punishments that are different than the regular Kansas criminal trespass statute 21-5808. For several sections, the punishments are increased. They're at a higher level. By the way, that's not unusual in Kansas law. Kansas also has a separate criminal trespass statute for trespassing on nuclear generating facilities. And the other thing that would be important is it was a policy decision by the legislature to highlight the significance of these facilities and the need for protection. And that's certainly within their policy judgment to have declared.
But on the nuclear facility, does it have anything to do with speech that you falsely, and you made statements to get on that were false, or that you went on with the purpose to later disparage the nuclear facility?
No, Your Honor, that provision, which is 66-2303, does not have those kinds of provisions. It provides for
difference. I mean, that's certainly a big difference here. In Alvarez, the Supreme Court, focusing on the fraud, the lie, as you put it here, said that there was no right to prohibit people from telling falsehoods for falsehood's sake alone.
That's correct.
And here, so you have to show that there's some harm from the falsehood here, right? The lie to get on the property. And frankly, I think your best argument is the offer of employment, but you didn't make that in the district court, and you didn't make it here until your reply brief. So I think that one is gone. So for me, then the issue is whether trespass standing alone is enough to overcome the Alvarez decision. Can you tell me why that should be the case?
Well, the Alvarez requirement, and I'll come back in a minute to the offer of employment. The Alvarez requirement is that there be some material harm or damage. And trespass traditionally is the type of tort civilly where just nominal damages apply even if there are no proven damages. So the nature of trespass, it is one of those property rights in the bundle of sticks that when it's violated, it's deemed to have damaged or hurt the property owner. So we would contend that trespass in and of itself is sufficient under the Alvarez analysis. I think it's important to mention that Justice Kennedy twice in his plurality opinion referred to a lie as the basis for an offer of employment as something that could be actionable consistent with the First Amendment.
And that might be a really good argument if you had made it, but you didn't. You made it for the first time in your reply brief before us.
We would have to rely on the record there. We believe that it's a valid argument in the case, Your Honor.
Let me ask you a different question. You said something which I didn't think was correct in answer to a question from Judge McHugh, and I want to make sure you're saying it. You said that the nuclear facility trespass statute doesn't prohibit deceit to obtain access, but that is common law under the restatement of torts, second torts, and it was stated as the law in a civil context, similar to this, in a Kansas Court of Appeals decision. Are you saying that someone would not be guilty of criminal trespass of a nuclear facility if access to the facility was obtained through deceit, through a false statement?
No, not at all, Your Honor. What I was referring to
is that there's not specific language to that effect.
That's correct. The statute doesn't contain the same language as the Farm Animal Protection Act. But you're correct that under the common law of criminal trespass, entry by deceit would still be a trespass as to a nuclear generating facility. That separate statute provides increased penalties for trespassing at a nuclear generating facility.
And that's because in general law, it's not true everywhere, but generally consent is not effective if it was obtained through fraud, through lying to somebody. Isn't that correct?
Yes, I believe that is correct.
And it's been stated as the law in Kansas, has it not?
Yes, I believe that would predate this statute as part of the traditional law of trespass.
I wanted to clarify that. Go ahead.
Very good. As to the second reason that we believe the district court is wrong, we believe these Kansas provisions fall into a well-recognized category of unprotected speech by regulating only false speech that is intended to inflict damage. And this goes to the question that you were asking, Judge McHugh. We believe that the distinction is that false statements accompanied by harm are not subject to the same protection as in cases of defamation, fraudulent solicitation, or other causes of action. Alvarez criminalized only falsity and nothing more.
The harm here flows from the videography or the pictures. It does not flow from the false consent form. Isn't that correct?
Well, we don't believe that's entirely correct. That is a separate First Amendment argument that once the trespass has been committed, they should be allowed to engage in First Amendment activity using the benefit of the trespass. So that is only the second of the First Amendment arguments that they make. I would like to reserve the rest of my time for rebuttal.
That make it a worse argument just because it's number two? Isn't that the point? That the harm here, if any, flows from the pictures, not from the consent.
Well, the harm flows both from the fraudulently obtained consent and then what's done after they obtain access based on the fraudulent consent, based on the trespass. And the second element, the photography or the video, is not in of itself a protected First Amendment activity. They don't have a right to commit trespass.
You would agree, wouldn't you, that when you say that there's harm from the consent, that this is a chain of causation theory you have, and that is, if they hadn't done the consent, there would not have been the pictures, and the pictures caused the harm. Therefore, the consent is part of that chain, and the consent caused the harm too. Isn't that the theory that you're relying upon?
Yes, I think that's our argument. Yes.
All right. Thank you.
I would reserve the balance of my time for rebuttal.
Professor Chen?
May it please the court. Good morning, Your Honors. Alan Chen, representing the Animal Legal Defense Fund and the other appellees. This case involves, as you know, the Kansas statute that it represents an attempt to shield the animal agriculture industry from public scrutiny by punishing undercover investigators who reveal information about animal welfare, food safety, and labor conditions, all matters of profound public concern. I'd like to take a minute just to put the enactment of this statutory provision in context. Mr. Lau points out that the original act was enacted in 1990. It was not until 2012 that the Kansas legislature amended the law to add the anti-deception provisions that make the types of undercover investigations my clients are involved in illegal. That is roughly around the same time that several other Western states were adopting similar provisions of what we call ag-gag laws. And we believe that the legislative history, as cited in our brief from page 41 to 43, demonstrates that the legislature had in mind animal welfare organizations at the time it enacted both the original law and the anti-deception provision in 2012. I'd like to first respond to Mr. Lau's argument about trespass, which obviously is one of the major issues here. This is no ordinary, generally applicable trespass law. As the court has already pointed out, general trespass law already protects property rights or property owners' rights to exclude others, as both in the civil common law of trespass as well as the criminal statute enacted by the Kansas legislature.
So do you agree that anything that your clients would want to do that would violate this law could be prosecuted under the general criminal trespass statute?
I don't, Your Honor. I mean, I understand you're saying this 1979 Court of Appeals case involving the television station. That involved a completely different set of circumstances where the...
Yes, but it stated a principle that's stated in the Restatement Second of Torts, did it not?
It did. It suggested that in conflict with other jurisdictions, that deception might vitiate consent.
Well, when you say there's some jurisdictions that say it's forbidden and that deception doesn't matter. Some say can. There are jurisdictions that say you can't record a conversation with somebody unless both of you agree, and there's some that just require one person to agree. So Kansas has a recognized property right that you cannot come on my property by obtaining my consent through deception. And that seems to distinguish Alvarez because that's a legal interest that is violated through deception. So I'd like to, there are lots of ways to attack this statute. And I want to try to figure out what the heart of the problem is. And it doesn't seem like it's the deception.
So we respectfully, I disagree, Your Honor.
I suspect you do.
So Alvarez says there has to be a legally cognizable harm, and maybe
what's the exact language? Doesn't it? Is it legally cognizable harm, or does it talk about a legal interest?
It talks about legally cognizable harm. It also talks, Justice Breyer's concurrence talks about specific harms to identifiable individuals. But our argument here is even if this were a technical trespass under Kansas law, the types of interests that are underlie trespass law are protection of a property owner's ownership and possession of the land. Once somebody, even if somebody accesses property through deception by lying about their affiliation with an animal protection group, it does not cause the types of trespassatory harms that the law of trespass is designed to protect.
Well, let's explore that. Let's explore that. Say someone comes on the property and then starts filming. And the owner says, I don't want you doing that. You're going to have to stop. And the person says, no, I have a First Amendment right to continue to film this. And the property owner says, well, I'll call the cops then. And the person continues to film and stay there. And the cop comes I'm not, and the cop arrests the person for violation of law, criminal trespass. Is that a violation of the First Amendment?
In that context, Your Honor, so are you saying the initial access was through deception? And
no, I'm just saying someone's on. I'm going to take it step by step. Someone comes on my property, and you're saying I have no interest in keeping someone from filming it. I'm asking, does that mean that someone could continue to film even after I said, get out of here, I don't like you're doing it? And could that person be prosecuted for criminal trespass?
Probably, Your Honor, under the Kansas statute. So that is because
so what if I said, I just want to take a string of hypotheticals here to see what the issue is. So say someone comes on my property and then wanders in the back and starts photographing things that were not open to the public. And a security guard sees this on a security camera and tells the person to leave. Same result. Does that violate this person's First Amendment right to arrest him for that, him or her?
Well, first of all, there's a difference between civil trespass and criminal trespass.
No, I'm asking, say it's criminal. Okay. Let's say a criminal case.
Right. So if the conduct preceding the filming is itself illegal, that's a different situation.
No, I'm not saying that. I'm not saying that. Well, okay, in this case, yes. When the guy goes in the back, yes, okay.
So what our argument is that the unique thing about ag laws is they couple two elements of expression that are protected by the First Amendment. First, the freedom to lie under Alvarez when it doesn't cause a tangible or material harm.
Okay. Well, that's why, okay.
The prohibition on filming.
Yeah, I think I know what your argument is. I'm trying to see how it holds up under different hypotheticals. What if I posted a sign outside saying no filming? Or you promised, or you cannot come in if you come in, I promise, well, say there's a convention and I want everything off the record. I'm the organizer of the convention. I say, you have to promise that you won't do any filming. You won't record anything here while you're here. And then you say, yes, you lie, and you come in and you film. Is that a violation of the First Amendment if that person is prosecuted for trespassing in that circumstance?
Again, Your Honor, there's a distinction. So the property owner in that case, the convention operator could file a breach of contract action under a generally applicable breach of contract law. They might be able to argue for some sort of fraud under generally applicable law. But that's not this law. This is the law. Okay. This law imposes the power of the state to criminalize this conduct and put. Okay. So I want to focus on what it is that's wrong about this, okay? Right.
And you're saying that if this person who entered the convention under a false promise and recorded stuff, that would violate that person's First Amendment rights to criminally prosecute that person. Is that what you're saying?
Yes. Because the deception
is. What if it were a convention of abortion providers who did that? Are you aware that someone's been prosecuted for that?
I understand there's some civil litigation going on about that.
Well, there's been a criminal prosecution too. And you're saying that person is protected by the First Amendment from.
In the scenario that you've offered, Your Honor, and the hypothetical you've offered where there's deception about access and then there's filming and it's punished by criminal law and put in prison, yes, I believe that person would have a First Amendment right. There's a distinction between the convention organizer's right to file a breach of contract claim or a fraud claim.
Yeah, okay.
But not.
Why is that? Why? Yeah.
Because now you're empowering the state to use coercive force.
Let me interrupt.
No, please.
I'd like to focus on whether this statute is content neutral and viewpoint neutral. And I'd like you to tell me, even if we were to accept that that there were otherwise unprotected, can you have a statute that is not? Are there problems with not being content neutral and viewpoint neutral?
Are you talking about the RAV argument or on our principal argument about the actual statute, Your Honor?
The actual statute.
The actual statute is both viewpoint and content based. As the district court held on its face, the statute only punishes people who engage in the deception with the intent to damage the animal enterprise. That is not the type of physical harm that is prohibited under subsection A of 1827, but clearly it extends to, and the state has not disavowed this, extends to types of reputational harm or publication harm that the federal courts have said the damages cannot be imposed on First Amendment activity outside of the context of defamation. So if
I lied to enter this animal facility, but I did it because I wanted to post letters of appreciation to the facility and then write an article about how great it was, I wouldn't be liable under the statute, correct?
You would not have the requisite intent to damage the enterprise.
And is that problematic for the constitutionality of the statute?
It is. It targets people who are critical of the animal agriculture industry and not its supporters, as the district court properly found.
Well, isn't that standard in criminal law, that intent to harm? If you committed an assault with intent to do something, go ahead.
Sorry, Your Honor, Judge Hartz. The problem here is that there's no limiting principle. There's no definition in the statute that limits what intent to damage the enterprise means. So we have no problem with saying that the state has the authority to prohibit somebody who lies to get onto an agricultural property in order to destroy it or to set it on fire or to do physical, actual, tangible damage. But the statutory language here is not limited to physical or tangible harm, which is really addressed under subsection A. So it clearly includes reputational harm and publication damages, as Judge Murphy pointed out, because what the state is really concerned about here is the bad publicity that's going to be provided to the public about the treatment of animals and food safety issues and labor conditions in this industry, which is clearly a matter of public concern. Turning back to Judge McHugh's argument.
So this is an overbreadth claim? I didn't notice an overbreadth claim.
We filed an alternative overbreadth claim, Your Honor, in the district court, but the court did not feel the necessity to reach that claim.
Okay, so let's assume that let's eliminate the overbreadth and leave that for the district court for a possible future consideration. Absent the overbreadth claim, I'm sure you're familiar with Wisconsin versus Mitchell.
Mm-hmm.
And that said, if you, what was it was disorderly conduct or something, and if it's with racial animus, that's okay. It's all right to increase the penalty for racial animus.
Right.
But yeah, go ahead.
That's a sentencing enhancement case, Your Honor, as opposed to a case that involves the crime itself.
Well, but I thought we've already established this is essentially a sentencing enhancement statute because the same conduct is already prohibited in the general trespass law.
Well,
do they have to be in the same statute? If this were an added provision to the general criminal trespass statute saying additional penalties, which the jury has to find, would that make a difference?
Again, if the trigger of the criminal punishment is the intention to engage in First Amendment activity, yes. And the court in Wisconsin versus Mitchell does not conflict with that. Before my time is out, I'd like to add one.
I'm going to give you plenty of time. You'll have plenty of time. This is worth pursuing, so don't be too tight about that. So are you focusing then on the provision of the statute relating to filming? Because that's the only language in the statute that we're considering that specifically addresses speech. Go ahead.
So no, the anti-deception provision specifically targets speech. As the district court found, this law criminalizes the conduct of my clients based on what they say or may not say. So the deception as well as the photography provision, those are two distinct ways in which the law regulates speech that's protected and covered by the First Amendment. I wanted to also add.
Okay, let's set aside the deception for a moment. And then the First Amendment flaw is limited to the filming, the video recording and photography provision. Is that, are you saying that?
Yes, Your Honor. The creation of a video is protected speech.
But for the other provisions of the statute, the First Amendment problem is limited to the deception provision in the statute. Is that correct?
Correct. But subsection C, which contains the video provision, all four of those subsections could be violated by videography or photography because there's an intent subsection, there's an entering with the intent to video record. So all of subsection C prohibits video recording.
But if the video recording part were eliminated, the flaw in the statute would be, the only First Amendment flaw would be the deception. Is that, am I understanding you correctly?
Correct. So the deception, again, as we argued, does not in this context, the deception does not cause the kinds of trespassory harms that the courts have typically recognized. As this court held in Western Watersheds Project, right? That case also involved a criminal statute where there was a de minimis touching and concern on a crossing there. This court did not hold, it found that there was a First Amendment right, that the Wyoming data trespass law was unconstitutional.
Yeah, I was on that panel. I'm familiar with that.
I know you were. If this court were to uphold Kansas's argument, the implications for free speech would be wide, because the same types of deception to gain access to private property that are used by my clients' investigators are also used by undercover journalists, by civil rights testers, by union salts, as pointed out by the United Farm Workers amicus brief, by investigators pursuing False Claims Act claims. Even law enforcement officers would technically, engaged in a sting operation, could be technically prosecuted under the statute by disguising their identities as law enforcement officers and gaining access to an agricultural facility.
Well, why is that? I don't understand what's so terrible about prohibiting deception when if the person goes ahead and does something, they could be removed from the property and it wouldn't be a First Amendment problem. That's why I went through the hypothetical about someone's on my property and taking pictures and they haven't used any deception up to then. I say, get off. If I can do that, why can't I say beforehand, you cannot come in if you're going to photograph? Like the Indian Pueblos in New Mexico don't allow photography, or they at one time they didn't, some didn't. And or you have off the record proceedings and you don't allow cameras in the courtrooms.
There's special interest involved.
Yeah. So if I can prevent you, if I can kick you off for doing something, why can't I say you can't come in unless you promise not to do that? Why then can't you be prosecuted for lying about that, just as you could be prosecuted for not leaving after I tell you to leave if you are? Explain what I'm missing there.
Well, the property owner is perfectly, there's nothing about the law that the First Amendment that prohibits the application of generally applicable common law, contract, and tort principles. And the First Amendment, as is not a defense to generally applicable laws, but that's not what this law is. This law specifically targets the very conduct that is used by undercover investigators to reveal misconduct and to publish information of great public concern. So yes, if an employer says, you signed this contract and that says you're not an animal rights investigator, the employer might be able to sue for breach of contract or terminate the employment based on a misrepresentation. That is different from what the state has done here, which is imposing criminal penalties.
Well, could they have been, but apparently it would also be violating the Kansas General Trespass Statute.
Well,
so if that's correct, maybe you want to challenge that, but if that's correct, then if we eliminated the recording, video recording, et cetera, provision, then why would this statute be any more offensive than the General Criminal Trespass Statute? Why would it be a violation of the First Amendment to prosecute under the Kansas statute as changed by us, but it wouldn't be violative of the First Amendment to prosecute under the General Criminal Trespass Statute?
Again, the general criminal trespass statute requires the posting of notice and the informing the trespasser that they are no longer welcome on your property. So,
but isn't that? But I thought that's what's required by this statute. It says they have to have notice, and the notice can be a specific sign, or it can be just understood, or is the problem here that it doesn't require the agricultural facility to put up a sign saying no photography, no video in here?
Only subsection D sort of mirrors that provision of the Kansas criminal trespass statute. The other provisions do not, Your Honor.
I'm sorry, I missed something there.
I said subsection D is the only subsection that mirrors the notice provision of the generally applicable Kansas criminal trespass statute.
Well, I thought, okay, maybe I missed something there.
And
Go ahead.
If I could just sort of add the point, and I will point out that we asked for 30 minutes for this argument.
I missed that. I was wondering, why are we just giving 15 minutes? So I apologize to my colleagues, but I think this deserves 30 minutes to a side, but go ahead.
I appreciate that, Your Honor. The other thing I wanted to say was about your question about invalidating only the video recording portion of the statute. Unless the entire statute is invalidated, as the district court held, there's no way for investigators to access the property in the first place, because they're not going to walk up to a slaughterhouse and say, can we come in? We're from the Animal Legal Defense Fund. Can we come in and film your properties and your operations in order to reveal possible illegal or unethical conduct? So striking down only the video provision is really sort of a half measure in terms of the ability of this type of investigation to be conducted in the state of Kansas. And again, this applies not just to animal rights investigators, it applies to journalists and civil rights testers and union assaults, both of which the U.S. Supreme Court have recognized engage in lawful activity when they lie about their backgrounds in order to gain access to private property, in order to reveal, in the case of civil rights testers, racial steering practices by realtors and landlords. And in the case of unions, the Supreme Court has recognized that someone can lie about their union affiliation in order to get a job at a non-union workplace in order to organize. Both of those things.
Was that a First Amendment case or under the National Labor Relations Act?
It's under the National Labor Relations Act, as is the civil rights testing. But my point is that it would violate Kansas law for an organizer to go into a slaughterhouse and try to organize its employees without identifying themselves as a union, as a member of the union, as a hired paid union organizer, as it would a civil rights tester who wanted to find out if a slaughterhouse was engaging in employment discrimination. They would be gaining access to the property for their job interview with the intent to damage the enterprise to the extent that the results of their investigation would result in the enforcement of federal civil rights law. or in the case of the union, the intent to damage would be organizing a union that would result in a collective bargaining agreement that might require the animal enterprise to pay higher wages or improve working conditions. Both of those things would be, because again, this Kansas legislature did not see fit to limit the definition of damage to the enterprise. Both of those things would be criminal under the statute as it exists. So the scope is far and wide. Now, I'm not sure I completely answered Judge McHugh's question about viewpoint and content discrimination. I also wanted to point out that in addition to the overt intent requirement, which as the district court held, makes it facially viewpoint based, the law is also content based in sort of more mundane ways, which is that the law prohibits false speech and allows truthful speech. But that form of content discrimination is the reason that the Supreme Court had to decide United States versus Alvarez. Punishing false but not truthful speech that does not cause a material or tangible harm under Alvarez is a form of content discrimination that is forbidden by the First Amendment. In fact, the court described the Stolen Valor Act in Alvarez as a content-based speech regulation. In addition, the state has chosen to only focus on the animal agricultural industry with good reason, because the animal agriculture industry is so essential to the Kansas economy. But that focuses us on the idea that this law, that they don't prohibit undercover investigations of nursing homes or of child care facilities or other types of facilities that they are less concerned about protecting the reputations of, apparently. So that makes it a subject matter discrimination because it only focuses.
Let me ask about that. Would that argument wouldn't that ban any statute that focuses on one particular category of potential injured folks and not others? Would that prohibit a law that criminalizes threatening the life of the president but doesn't criminalize threatening the life of a judge? How do you distinguish that situation?
No, because the prohibition is the prohibition on the particular subject matter is animal agriculture. If you look at the definition of what an animal facility is, under the statute, it covers anything from a slaughterhouse to an animal research lab to a university to an elementary school that is conducting an experiment with a live animal. So it's this focus, it's the subject matter that is regulated, but the speech about the subject matter that's regulated, right? So it is just like the state could not pass a law prohibiting criticism of the agriculture industry, but not criticism of other industries. Right? That would be a subject matter based just form of content discrimination, also triggering heightened scrutiny under the First Amendment.
I interrupted you while you were responding to Judge McHugh's question. Did you have
I was just, that's what I was doing just now, was trying to flesh out my content and viewpoint discrimination argument. So essentially we have two arguments why it's viewpoint based, two why it's content based. It's viewpoint based because of the intent provision, intent to damage the enterprise. It's viewpoint based because if you look at the legislative history, the Kansas legislature was clearly concerned about animal rights investigators coming into Kansas and doing the types of investigations that my clients have done in Texas and Nebraska, states that don't have similar laws. So those are the two viewpoint arguments. It's content-based because it regulates it prohibits false but not truthful speech, and it's content-based because it's focused only on the subject matter of animal agriculture. So I wanted to complete, that was a complete response to Judge McHugh's earlier question, but I got cut off.
Any questions? Okay. Thank you, Professor.
I appreciate the indulgence of the court with all this extra time, Your Honor.
Mr. Lau? You may proceed.
Yes, just a couple of points in response to the arguments of counsel. First of all, in parsing the statute regarding the video recording and photography, I think it's important to note that that is only one of the three sections of the statute that is at issue here. So if the court were to take particular note of that in a constitutional sense, that's only in subsection C of the statute, and subsections B and D could be upheld. Let me also then move to the content and viewpoint discrimination discussion that counsel was just having. So it seems to me that the first point he makes just has to be wrong. It cannot be unconstitutional as a matter of content and viewpoint discrimination to say that the legislature is focusing on a certain industry. That's a matter of policy judgment and policy preference about the legislature's determination of what is needed. And to say that just because one industry has a separate trespass statute and another doesn't, it somehow violates content and viewpoint discrimination aspects of the First Amendment, almost certainly we would say has to be wrong. The next argument would be someone would be in front of this court saying that the statute regarding nuclear facilities is wrong because it's some sort of content or viewpoint discrimination.
Well, the issue with content and viewpoint is whether in order to enforce the statute, you have to focus on the content of speech or the particular viewpoint advanced by that speech. In your nuclear facility, the statute has absolutely nothing that would implicate that. So I'm having a hard time following that argument.
Well, except that it is a statute directed at a particular industry, which I think was the first element of what Mr. Chen was arguing. The second element, in our view, is that it's not pure content or viewpoint discrimination. It's whether it is impermissible content or viewpoint discrimination. And it's not impermissible when positive views have no possibility of inflicting harm to the enterprise.
Can you point me to anything that says that truthful speech is harmful?
No, I don't believe so, which is the reason that
if they film what's actually happening and then they publish it, it's truth. It's truthful speech. I don't think you get to hang your harm hat on truthful speech.
Well, the point of the harm here is that the statute provides for the harm to the enterprise or the business that's conducted there. And the supposed discrimination consists entirely of the very reason that this entire class of speech is prescribable. The reason it is prescribable is because it causes harm, just like the false statement by the security salesman subjects him to securities fraud charges. A security salesman who gives correct information isn't subject to the First Amendment because of the truthfulness of it. There's no interest.
Even if the truthful information is harmful to the business because it reduces sales, right?
I think we're talking about two different elements of truth and harm. I'm speaking about the harm that comes from the dissemination of the speech. You're speaking about the harm that comes from the video or photography aspect of the speech. Here, that's part of the chain I was discussing with Judge Murphy.
But I'm not understanding your argument. Are you telling me that you can claim harm even if every aspect of the speech is truthful?
Oh, certainly. For the same reason that the speech was unprotected in the first place. The speech was unprotected in the first place because under Alvarez and all the cases that say you cannot trespass get the right to trespass based on the First Amendment. There is no basis for, notwithstanding the fact that the video they ultimately make wrongfully, inconsistent with the way in which they obtained access to the property, notwithstanding the fact that it shows what actually happened or occurred, they had no right to make the video and they're still subject to prosecution under the statute, consistent with the First Amendment. Finally, just a couple of other points that I would like to make. I think it's worth noting that this statute does not ban all First Amendment activity by groups like the plaintiff group here. It just affects their preferred method of engaging in First Amendment activity. They have many alternatives. Justice Berger referred to the availability of alternatives in the KQA case, where he said that they could get letters from the prisoners inside of the jail facility. In the same manner here, the plaintiffs have the First Amendment right to look outside the facility, to attempt to make contact with folks working at the facility. Simply, the ban here is on their preferred method of First Amendment activity. Finally, I wanted to bring to the court's attention that many of these same issues are pending in the Eighth Circuit in a case that was argued in September and is pending decision.
You have the name?
Yes, that case is ALDF v. Reynolds, and the case number is 19-1364. In conclusion, Your Honors, agriculture is a vitally important element of the Kansas economy, and the potential harm from unauthorized intrusions like those at issue here is very real. The Kansas legislature acted reasonably when it passed the trespassing law at issue here, and that law does not violate the First Amendment. The district court should be reversed.
Thank you very much, gentlemen. Case is submitted. Counsel are excused. And we'll go to our last case of the day now. 20-4027, SS&C versus Consultores, etc. Mr. Thomas, you ready to proceed?
Thank you, Your Honors. Good morning. May it please the court, Nathan Thomas on behalf of SS&C Technologies. SS&C Technologies appeals the district court's order dismissing its complaint on the basis of a forum selection clause. It's well established that the proper means by which to enforce a contractual forum selection clause is through the doctrine of forum non-conveniens. Here, having determined that the forum selection clause in the parties' agreement was enforceable, the district court applied a modified forum non-conveniens analysis that gave almost dispositive weight to the forum selection provision. SS&C submits, however, that the district court erred in its determination that the applicable clause is enforceable under the laws of Mexico, and as a result, further erred in its abrogation of the forum non-conveniens analysis. I would like to focus today on the first part of this, the court's threshold error, its conclusion that the forum selection clause is enforceable under the laws of Mexico. And to the extent time permits, just briefly address how this erroneous conclusion resulted in a misapplication of the law of forum non-conveniens. In framing the issues before the court, I think it's first important to note what is not in dispute between the parties. It is not disputed that the parties' relationship is governed by a contract that is to be interpreted, construed, and governed by the laws of Mexico. It's also not disputed that the contract also provides that any action, suit, or proceeding related to any dispute or controversy arising out of the contract was to be, quote, brought in the state and federal courts of Mexico. Ultimately, the parties also do not dispute that this provision, as written, is unenforceable under the binding statutes and mandatory binding precedent of the laws of Mexico.
Well, I think your opponent's going to say that there's not agreement on that one.
I believe they probably will, Your Honor. That being said, the decision made below was not made based on the laws of Mexico. It was based upon a single decision that was adopted by two courts in Mexico in litigation between these parties.
Let me ask you this. What if you had the very same case, except the decision from the other court was a case from New Mexico rather than Old Mexico? What would you say to the decision of the New Mexico court, which was wrong, but it was their decision? Would you say the same thing, just ignore it?
I would say, Your Honor, that I think this is answered by looking at Rule 44.1, which does exactly what you're saying, Your Honor. When it was passed, the intent, as articulated in animal science, was to make the determination of foreign law the same as the court would determine domestic law. In that case, they specifically referred to, I believe, that if the law of the highest court of the land is the one that you are to follow, then that is what you are to follow, and you would make the same determination. Thus, if it was a court in New Mexico making a determination rather than Old Mexico, you would look at that within the hierarchy of binding precedent within the domestic system. If it was a court from that is a superior court and it has binding authority, then you would have to adopt that decision. But that's not what we have here.
But it's a final decision in this case in a different jurisdiction. It just so happens to be a foreign jurisdiction rather than another state of this union. And I mean, it seems to me that if you can disregard the decision of the Mexico courts in this case, you can ignore the final decisions in the same case from the state of New Mexico.
In that respect, Your Honor, this is not the same case, and it was a different issue that was being addressed. In that case, SS&C was the defendant and had challenged whether it was subject to jurisdiction as a defendant in the courts of Mexico. And it initially prevailed on the basis of the binding authority. I'm sorry, Your Honor.
Well, the challenge was based on the same argument that you're making now, which was that because they didn't name the specific judge, that therefore it was invalid and couldn't be enforced. And that argument was soundly rejected and the provision was upheld. I mean, that's pretty darn close.
I mean, I understand, Your Honor, and I understand where you're coming from on that. Ultimately, that would be almost a res judicata argument, a collateral estoppel or an issue preclusion argument, but that's not what the district court did.
And it's not. I wouldn't argue that it's collateral estoppel or issue preclusion. I would argue, like Judge Murphy does, that we're looking at it essentially like we would if we were sitting in diversity under Erie, and that we can't ignore the decision of two Mexican courts that have rejected the very argument you're making here between the same two parties over the exact same provision in the same contract.
I understand that, and I don't think it should be ignored. Rule 44.1 makes very, very clear that a court in determining foreign law is free to consider anything submitted by the parties or that it determines on its own is pertinent to the determination of the law. Ultimately, that determination of the law should be a determination of the law, not of a particular decision. Adopting these decisions as the law of Mexico as set forth in the declarations that were appended to the...
They are the law of Mexico. We have a Mexican court that has interpreted the very article of Mexico law that you're relying on and saying it doesn't invalidate this provision. How isn't that a decision of law from Mexico?
Well, the ley de amparo in the Mexican system provides that judicial decisions only have binding authority if they are the same conclusion is reached by 5 different courts in 5 different sessions unanimously without interruption. That's what makes that law binding. And this is an aberration from that binding precedent. And in that respect, to the extent we look at what is the binding law of Mexico, this is not it on any other litigant or in fact upon us except in that particular case.
Underlying everything here is you got homered, right?
Well, ultimately, Your Honor, that matter has now been resolved in favor of SS&C, as I understand it.
You got homered in the Mexico decision, correct? And that's what.
Well, in Mexico, SS&C never did want to litigate in Mexico. The ultimate result in that case has been positive.
And why did they sign this agreement that had it in there? That's what I'm getting to, is that you're complaining about being homered, and you took that risk. Your client took that risk when they signed this agreement. So
I understand, Your Honor, and I cannot argue that they didn't sign that agreement or that the language is anything but what it is. The argument that we've made is the one that under the commercial code and under the binding precedent, mandatory precedent, that is an unenforceable provision. Yes, the court reached a different conclusion in the Mexico litigation, but it remains that is contrary to the binding authority in Mexico.
In the binding authority that you rely on, there's not a single one of those decisions that involved citizen not of Mexico. They were decisions between two parties in Mexico suing each other, right?
I believe that's the case, Your Honor.
Well, I can see why a court might view it a little differently under these circumstances and look at the obvious intent of the parties that your client would subject itself to suit in Mexico.
What the court was thinking and what the basis for its determination, the Federal Court of Appeals that ultimately found that there had been a waiver of jurisdiction and what its motivation for doing that is a bit unclear, as it did not cite any binding authority. What we are left with is what the Commerce Code says and what the binding authority says. And I don't believe there's a distinction that's been articulated by either of the experts whose testimony was proffered to say that there was an exception to a non-domestic party. I think also, Judge McHugh, what you raised is an interesting point, and that the question there I do think is distinct, in that it's not unheard of for a party to be required to sit as a defendant in a particular jurisdiction. But at the same time, that does not necessarily require all lawsuits be brought in that jurisdiction. A Utah resident may be subject to suit in California, but it is not obligated to bring all of its suits in California, even between the same parties. And in that respect, it is a slightly different question that was being answered here, and one that doesn't preclude this case from going forward. Ultimately, we believe that under 44.1, the district court had an obligation to apply the law. Oh, I'm sorry, I did not hear you, Judge Hart.
No, I was muted. I had to turn on mute when the phone started ringing again. So here's my concern here. We are not bound by those decisions. We're trying to decide what Mexican law is. We have decisions by those Mexican courts. You're saying those decisions are wrong, but you really don't give us a lot to work with. We have to take your word that those are contrary to Mexican decisions. And if your brief had gone through the Mexican statute and explained things and shown all the cases that have rejected forum selection clauses like this, then maybe we could help you. But I don't see how I've got anything to work with to rule in your favor, except to say you're a nice looking smart guy, so I guess you're probably right. and that might not.
I will take that, Your Honor.
Pardon?
I would take that if that gets the result we're looking for. I would refer the court to the declaration of Ramon Fernandez Vigil that is in the appendix at page 924.
This is your counsel?
All of that.
Your Mexican lead counsel from the Mexico litigation? Yeah. That's probably not your best choice of an expert.
Well, but
I would also,
even so, it says what you want them to say pretty much, but it doesn't explain it. It doesn't explain it. It's just too conclusory. Go ahead.
Well, the precedent was also attached, and I would note that on reply below, this was not really a point that was disputed. The Consultores Pueblo Bonito relied upon these decisions in the case between them in that litigation without rebutting the testimony of Mr. Vigil and without rebutting the proposition that these were binding authority under the system created by the Ley de Amparo. And in that respect,
go ahead. It seems to me that when you have a conclusory statement and you respond by giving 2 court decisions to the contrary, that's pretty good rebuttal. But proceed.
well, I would just respond to that by saying there are 2 decisions that are not binding on anybody other than the parties to that litigation in that litigation, whereas the Commerce Code applies.
Counsel, your opposition had full opportunity to put in a counter affidavit and chose not to do so, right?
That's what I'm saying. Well, on reply, they could have responded to that. We were opposing the motion, and they would have had an opportunity to reply to that, and they did not.
So the only thing we have is to opining on what the Mexican State Court did is your expert, correct?
They did offer the testimony of their lawyer in Mexico as to the proceedings below in their moving papers, but he did not respond to the testimony from the lawyer that we submitted, Mr. Vigil. I would submit, Your Honors, that Rule 44.1 requires that the court apply the law. The laws of Mexico in this case to determine if the foreign selection clause is enforceable. And under the law, under the Commerce Code and the precedent, the mandatory and binding precedent that flows from that, it is the law of Mexico does not render this provision enforceable. And as a result, the district court's decision to abrogate or apply the modified form of nonconvenience analysis and give great weight to that foreign selection clause was erroneous. And on that, Your Honors, I would submit.
Let me ask you one question. It doesn't appear that you present any alternative arguments that the district court abused its discretion when considering the public interest factors. So if we disagreed with you and said the modified version is appropriate, you haven't raised any argument to the application of that. Is that's how I read your
book? To be very frank, Your Honor. Yeah, to be very frank, Your Honor, I think Atlantic Marine is quite clear in the progeny that dictate that in large part an enforceable forum selection clause will be given great weight, and his determination on the public factors we don't take particular issue with. We do take issue with the non-consideration of the private factors.
Thank you.
Mr. Merriman?
Thank you, Your Honor. May it please the court, Ryan Merriman appearing on behalf of Consultores Pueblo Bonito. This case, as you're well aware, involves 2 sophisticated commercial entities that engage in an international business transaction, access to counsel, plenty of resources, and they entered into a contract that has what appears to be a fairly unambiguous forum selection clause that we've all read several times in reviewing these briefs. The concluding sentence in that clause is that the parties hereto submit to the exclusive jurisdiction of such courts, the courts in Mexico. We have parallel lawsuits filed, and as the court is aware, SS&C Technologies tried to dismiss the complaint in Mexico, raising arguments that I don't see any difference from what have been raised in the briefing and today. The core argument was that under the Civil Code, Section 1093, that in order for there to be a waiver of jurisdiction, they had to specify the specific Mexican state or court or even the judge. Otherwise, it wasn't enforceable. It wasn't clear and specific. And the courts rejected that argument decisively. We have to interpret this provision under Mexican law to decide if this suit should be governed by those authorities to decide what Mexican law is. And of course, under Federal Civil Procedure 44.1, this court can consider any relevant material or source to determine foreign law. And so I think the analogy that Judge Murphy raised is a useful one, because 44.1 is supposed to make the determination of foreign law as close as possible to how you would determine law in New Mexico or Pennsylvania, any other jurisdiction. And so what would we do if you're sitting in diversity jurisdiction, you're trying to figure out what the law in New Mexico is? I think a good analogy would be, what if you had an unpublished appellate court decision from Mexico, from New Mexico, on the very same 2 parties in a case that was later brought in federal court, And the party in federal court was saying this unpublished decision is wrong based on these published decisions. They're probably out of luck. I mean, there'd probably be a Rooker-Feldman issue, I would imagine. But a lot of the cases that have been cited, particularly in the reply brief, this United States Supreme Court case, the vitamin case, those are all cases that don't involve facts like this, where you actually have parties that were litigating in the forum that come back to a United States jurisdiction and try and say, hey, this decision back here, it's just wrong. They just whiffed on the law. Those cases all involve statements by foreign government officials, administrative agencies, dueling experts that are citing precedent from other cases that seem to be similar. And in that respect, I don't think there's really a lot more that this court has to do than look at what the Mexican courts held and apply that law. Those decisions are a reflection of Mexican law.
Let me interrupt for a minute. I mean, if we look at Article 1093, which frankly, I didn't see a word-for-word translation of it in your materials, but there is one on Cornell University Library's webpage, so that was helpful. But it says that there's an express submission when those interests clearly and definitively renounce the one whom the law concedes them and designate with absolute precision the judge to whom they submit. I mean, that does sound like, in order to comply and make the clause enforceable as a matter of black letter law, you've got to name the judge with precision. Can't we don't have a decision from the highest court in Mexico. I mean, can't we look at that language and say these decisions are just wrong?
Well, you know, you look at any material, any relevant source, right? So certainly we should look at the plain language of that statute. And I would just point out that the courts in Mexico were looking at that statute, and their reasoning was it complies with that statute because by excluding United States judges and designating exclusive jurisdiction in Mexico, it was in effect designating judges in Mexico, and that sufficed. I think the precise language from the Federal Circuit Court in Mexico is that we don't need the sacramental phrase that they're waiving jurisdiction in the United States and designating a specific judge in Mexico. So the way that, and it's not as if these decisions are just rogue decisions. If you look at the decisions that have been provided in two different places in the record, one place is 224, volume 1, 224 through 34. They are citing precedent from other courts in Mexico that reach similar conclusions in similar circumstances. Now, counsel's correct that those decisions have not yet reached this mandatory kind of super precedent status because they've been repeated by 5 courts as the Amparo law requires. But they're not making it up as they go along. They have a basis for their decision, and they're interpreting the same language we have here, the same claims under the same civil code, and making that determination. So it's hard to conceive of more persuasive evidence of what Mexican law is than decisions from 2 Mexican courts interpreting our very contract with the civil code and making a decision as between these 2 parties on what Mexican law requires. On this argument that the issues are distinct, that the issue in the Mexican court system is different from the issue that's being presented here, I think the discussion, I think, kind of fleshed that out, so I won't belabor the point. But it is true that, of course, this case involves claims brought by SS&C against my client, and in Mexico, it was the reverse. Consultores Pueblo Bonito was suing SS&C in Mexico. But the substantive issue that was decided is, of course, the same. It was, is this forum selection clause enforceable under the civil code? Is it specific enough? Is the waiver clear enough? Does it pass muster? And on that substantive issue, the courts in Mexico held that it is. And so I think the real problem with that argument is, if you look at the language of the forum selection clause, it applies to any action, suit, or proceeding related to any dispute, claim or controversy that arises from this agreement. So if there was going to be a holding that, well, yeah, you could bring, my client could bring claims in Mexico, but his client can bring claims in Utah, there's no way to read that provision that would allow that. If it's enforceable and it applies, then all litigation has to take place in Mexico. I really don't, unless the court has further questions for me, I'm happy to submit.
Are you telling us that we should not be troubled in any way by the contradictory conclusions in the declarations? Shouldn't bother us one whit. Is that your position?
Between the declarations of the dueling experts below?
Yes. I mean, look, the declarations are pretty clear, aren't they?
So we have two experts. Our expert was my client's counsel in Mexico. SS&C's expert was its attorney in Mexico, and they're advocating on behalf of their clients, and they reach diametrically opposed conclusions. If you're trying to figure out what Mexican law is, looking at evidence submitted by counsel that has a dog in the fight versus decisions from independent courts that are looking at it and applying Mexican law, it seems that's much more persuasive authority of what Mexican law is than an attorney who's advocating on behalf of the attorney's client. So no, I don't think we should be troubled that the experts disagreed with each other. Experts always disagree with each other. But the benefit in this case is that we have independent courts that are telling us what Mexican law is in this very same dispute on this very same question. Does the court have any other questions for me?
Thank you, counsel. I don't recall if Mr. Thomas used up all his time or not. Does anyone recall?
He is out of time, Judge.
You have to give us 38 seconds back, actually. So, very good. Thank you, counsel. Case is submitted. Counsel are excused. Court is in recess until 9 tomorrow morning. Thank you.